I expect you to call those first three before we get to any other person, not whatever order you want among the three, but those will be the three people called, and then we'll get to the next people according to the scheduling that I put in place yesterday.
I want to state for the record that I intend to appeal that judicial decision made about the motion to dismiss.
Noted for the record. All right, let's bring the jury out then.
Actually, we didn't address subject matter jurisdiction. It still has yet to be proven for the record, and I wanted to address the fact that with this, is it Kohler? Is that how you pronounce the name? Kohler?
We're going to continue with the witnesses. I've addressed subject matter jurisdiction repeatedly. There's a written decision. I stand behind it. You have three witnesses that you subpoenaed. The state made arrangements for them to be here. Whatever order you want to call them in this morning is fine, but those three are here.
That's what I was trying to address right now. I was asking about the name.
Okay, go ahead. What do you want to address?
The Kohler, how do you pronounce the name? Kohler? I'm still
I don't know.
having
You'll have to ask the witness.
I'm still having trouble finding the file for that particular witness.
Yeah, call the jury in.
So I don't know how I'm supposed to.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those three, whatever order you want, but I'm not moving past those three to jump to others.
I didn't say anything about moving past the three.
I know that. I'm just setting the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find
I
your
understand,
paperwork.
But that's you not having your paperwork's on you, not anybody else.
So what am I supposed to ask?
I can't answer that, sir. You know that.
That's a rush to judgment. You can't rush me to judgment when I'm notifying the court that I cannot find the record.
Well, you did very well yesterday without your file, so
I'm saying that particular witness.
I'll make a record. Yesterday you asked a question, hold on a second. Can you have them step back out? Just they can. Yesterday, you said you did not have a file for one of the witnesses, and you did a fine job from my perspective. So
I did what?
You did a fine job. I just want to say my assessment.
They also
you did
provided
a good
me
job.
with one sheet for that particular witness at that time. Okay. So I just went off of that 3 paragraphs.
How you're prepared or not is solely on you, sir. You've had all of this information. Now we're at the end of the 3rd week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How can I be prepared for? I'm not. So the witness is just supposed to get up there and just. I'm just I'm
not going to have this commentary. Okay, I'm done.
It's
the
his
jury's
problem.
coming out. Be prepared to call
So
one
that's
of the
a
three.
rush to judgment.
That is not a rush to judgment.
It is a rush
Again,
to judgment. It's clearly a rush to judgment if I'm telling you that I don't have the file.
In my opinion, you're attempting to delay. So
no, I'm not. I'm not attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks.
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah, and they deserve to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I still had another one that didn't have nothing to do with nothing we just talked about. There was a whole nother issue that needed to be addressed that I needed to bring on the record to your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
just like the rush to
judgment. Time for evidence to be presented or arguments to be made by the parties.
I can't even present any evidence. You won't let me even put any evidence in the record.
All of these statements made by Mr. Brooks at this time. All right.
That's unfair what you're doing.
The court will address legal matters outside the
presence. Then we need to address the legal matter that I was trying to get to before you rush everything out.
You may call your next witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant.
Mr. Brooks,
you're supposed to be able to answer simple questions.
Mr. Brooks,
if I'm saying I have to bring it to your attention. Call your next witness,
please. That's the stage of
I have to bring it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking to bring an issue to your attention.
I'm telling you to please. I'm asking you to please stop.
And I'm asking you
because we have the jury present.
I'm asking you.
We need to continue with the evidentiary phase of this trial. Call your next witness.
I'm asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will do that at the next break.
There was a legal matter that needed to be addressed beforehand, so we don't have to take up time, valuable time afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
for the
yourself are
third
on
time,
notice.
I will address it at the next break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath.
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going to take testimony right now. Call your next
I
witness.
merely seek to put you on notice on the record for something that needs to be brought to your attention and to the court's attention.
And I will address it at
That's
the
what
next
I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take a valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call
to
your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment
There
here,
is a
sir.
rush to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it
public
is
servant?
9:37. Call
It is
your...
8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next witness,
We had
please.
a legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
Telling you
at
I'm
the
denying the
onset.
request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call.
how can you deny
please
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day.
Oh my God.
So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down?
You can take a minute to write down what it is. I'm not asking you
why
to...
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath of office?
under
3 of them?
90611, this court has the authority, as you know.
Do I not have,
Call.
is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason, that these are three
Sir,
of your
you are
oaths
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here. You're doing this.
Listen, Your
we
Honor,
need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely
Gaslighting.
trying to
This is gaslighting.
notify Your Honor in the court for the
Gaslighting.
record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable
discretion,
time.
it's my authority, it's the courtroom that I'm
Your Honor.
presiding over. I'm not going to address
Is
that
this-
at this moment.
is this not your
and
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them. Here, your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me
next
to judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I
Call
object to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling, and if not that, an interlocutory, declaratory appeal for this matter, and if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction. Because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of the charges against me. I don't even understand that part of it. I haven't been provided a complaint. I haven't. Your Honor, there's so many issues.
Mr. Brooks,
I'm not attempting to be disrespectful in any way.
We need to continue.
To delay the proceedings.
Your requests are denied.
Your Honor, I
and I'm going to instruct the jury at this point to disregard and not consider any of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Your Honor, with everything that I just said be made part of the record?
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's a rush to judgment.
Mr. Brooks.
Because, Your Honor, I just showed your oath that you swore to took.
Means nothing.
You swore you
Mr.
did
Brooks,
this, Your Honor.
Please call your next witness.
You took these oath of offices. You did, Your Honor, 3 of them.
I understand my oath,
which is
sir,
very
well.
commendable that that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths.
All right, I'm going to have to excuse the jury since Mr. Brooks is not calling his witness. We'll hopefully bring you back out shortly.
You have to honor these oath of offices. You have to, as a public servant, Your Honor. I respect you being a public servant.
Gaslight.
And this is not to take a shot at you in any way, but these issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed.
I'm
excusing the jury. Can you please stop?
Every time he gaslights, put
Honor,
the gas can emoji in the chat.
This is a clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So
courtroom for the questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm advising you at this moment to call your next witness, or you will forfeit the right to call these witnesses.
Ooh.
You can't take
under 906.11.
Right.
You are refusing to call a witness.
I didn't refuse anything, Your Honor, and you can't deny me my Sixth Amendment right, which is
Mr.
to
Brooks,
call
do you want to
witnesses,
be present in
which
this
is to subpoena
courtroom
witnesses
while you question your first witness? Because it is now 8:44, and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you believe the law
didn't have anything
is.
to do with the
Subject
jury,
matter that is what you referenced in front of the jury, and then you referenced my oath.
The issues that I was
Subject matter
raise.
jurisdiction, as you know, is not
As I
something
don't know.
the state has to be. The state
It
must
has to
prove.
be proven. It has to be. And
You are
if it doesn't,
frankly
show me
confusing
lawful law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction in the state of Wisconsin.
You don't have criminal.
That
you
has
don't
been
even
made
have,
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction.
Mr. Brooks.
Or personnel jurisdiction. You don't. You haven't proven.
You have not. I
haven't proven
excuse
for
the
record.
jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now or we're moving forward.
That's what I want to do. That's what I was attempting to do.
And if you interrupt me one more time, you're going to go do it from the other courtroom.
Because
so
you're holding me in contempt.
All right. He can go to the other courtroom, and we will address these issues because you are not being respectful. You are disruptive. You are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes because of your nonstop commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said you have a legal issue you want to raise before we get going. What is that issue?
Okay. The legal issue is this.
Jesus Christ, dude.
Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that showed the backyard of my mother's home, which he stated that he had been to the home, had seen the backyard, all this stuff, when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
because
fine.
she's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to
away,
be addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break. All right, so
Will I be?
you're
because
putting
I have,
you're asking me to add Dawn Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena for whom?
for my mother. But I would also like to subpoena the phone records so it can be made part of the record of the conversation, since the prosecution listens to all the phone calls. They should be able to have heard that phone call as well. So they should be on notice of what was said.
I don't know what phone call you're referring to. If
I'm
you're referring to a
phone
jail
call
phone call,
I'm referring
then
to a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m., which I'm sure the prosecution has heard by now. And that also brings up the issue of perjury testimony.
sir, the way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her, and at the appropriate time we'll have her brought, we'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able
terms of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
That's what I was trying to gain knowledge of. Because
Well, I can't give you advice on that,
I'm
sir.
not trying to ask for advice. I was is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney, and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things, and that's how you'll have to address
I
that.
accept for value in return for value this document.
Was that a subpoena form?
It is.
Thank you. Is there any other witnesses you're asking to add to your, and you can also call Detective Casey if you want, just so you know.
So that make 3 times he's able to testify?
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
Well, in any event,
And he know what he didn't do.
we're gonna bring the jury back out, and then I expect you to call a witness.
And just so I'm clear, because I was trying to get to that issue, what witnesses are here? Because I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler, Stephen Guth, and Erica Patterson.
He doesn't
Of those
even know
three,
his witnesses.
I expect you to call one of those witnesses.
it. I accept for value in return for value this document.
For the record, Judge, Attorney Witchow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct.
You don't have it with you in the courtroom is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
So that's a personal problem. You lost it.
Are you ready to proceed forward, Mr.
There's a 40-year-old
Let's
clown.
bring the jury out.
Man, if you know anyone like this in your life, you need to cut them off, y'all. He's not the only one like this out here. He's the boss, the final boss of it, because he's got all of it. But help. 40 years old. Like the video, share the stream. You're watching the state of Wisconsin versus Darrell Brooks, December 21st, Friday. Happy Friday, everybody. Let me get a good morning in the chat. We're live on Facebook. We're live on YouTube.
Jen.
Share the stream on Facebook.
Zach, can you help Jen? I think she wants help on that last name. This team.
Again, the judge is dealing with so much heat from him to avoid a mistrial. As you can see, he's trying to get her in every way he can. He's trying to find every avenue. So she almost has to continue giving him
Make sure, don't
chances.
block any of the microphones with anything. Both of those microphones should be on. You want to make sure that. Thank you. All right, go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kohler.
All right.
First witness. Thank you, Barbara, for the
Good morning,
500
sir.
stars. Thank you,
Please
Jody.
Make your way to the witness stand, which is up toward me, up one riser, and to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Douglas Kolar, Douglaskolar.
Thank you. Go ahead, your witness.
Good morning, Mr. Is it Kolar?
Kolar.
Kolar. Good morning, Mr. Kolar. I want to direct your attention to November 21st of 2021. Do you recall that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time. Directing your attention back to the night of evening of November 21st, 2021. What did you do that day?
Well, that day, I was preparing my daughter to march in the parade with her dance troupe. Watched football earlier in the day and got her dressed, and we had to change our plans last minute because my son was not feeling well. So it was just my daughter and I that went to the parade.
And do you recall what time you arrived at the parade?
It was at least an hour before the start time of the parade.
And do you recall where you were positioned at in the parade?
I moved with the dance troupe, so I
Kind of going with the flow.
correct.
And at some point you observed something happening. Would that be fair to say?
Yes.
Do you recall what that was?
Well, after my daughter had finished and I was walking back to our vehicle to go home, I noticed as we were approaching White Rock, which is what we were parked off of, I noticed a vehicle coming through where the parade participants were going. It was a red vehicle. It was honking its horn. It passed a few parade entries on the right-hand side, and then it passed between two of the groups. It veered to the left and went around the next group on the left-hand side, at which point a police officer attempted to approach the vehicle. That police officer had reached for the door handle, and at the time of that approach, the vehicle started to speed off.
I just want to back up just a little bit. You stated that you heard the vehicle honking its horn.
While it was on White Rock Avenue, it was honking its horn.
In your opinion, did the vehicle appear to try to avoid hitting people?
At that point, yes.
And you made reference to it the vehicle coming in contact with an officer. Did you see where the vehicle went after that interaction with the officer?
There was no contact between the officer and the vehicle. The vehicle attempted to make contact. The officer attempted to make contact. But after that attempt, the vehicle sped southward. You know, I know those streets don't run straight north-south on Main Street.
Did you notice the vehicle strike anyone at that time?
I did not.
And what did you do after you saw the vehicle? Once it was out of your view.
Once it was out of my view, I grabbed my daughter and walked as fast as I could to my car.
And to the best of your recollection, how would you describe the vehicle as far as make and model? To the best of your recollection.
To the best of my recollection today, I only remember a red SUV.
At some point, did you report to law enforcement officers what you had observed that evening?
On the Tuesday morning following the parade, I sent an initial statement to the police.
Would that have been the Waukesha Police Department?
Yes, it was to the Waukesha Police Department.
You said you sent a statement. Did you initially speak with anyone verbally?
Initially, no, I did not.
At some point, did you speak with someone verbally?
Yes.
And was that sometime after the Tuesday statement that you initially gave?
Yes, approximately 2 weeks after I made my statement, I was contacted by someone with the Waukesha police.
Do you recall if the vehicle had any tinted windows?
I believe the rear windows were tinted like most SUVs are.
And after you had verbally speaking with law enforcement, did you do any follow-up on the reports after that?
Yes. The officer that I spoke to had advised me to add to my statement the items that we had talked about.
The law enforcement officer asked you to add certain things to your report?
He had asked me some questions, and the questions that we talked about on the phone, he asked me to add to what I had initially submitted.
And after that conversation, did you have any further conversations after that point?
I had no further conversation after that point.
Had you yourself been contacted by any further law enforcement after that point?
No.
So it'd be fair to say that you were subpoenaed to testify at some point. That'd be fair to say?
Yes.
Do you recall when you received that subpoena?
I received my subpoena last Tuesday.
The 18th?
Whatever day last Tuesday was.
Do you recall whom you received that subpoena from?
The Waukesha County Sheriff. Or
Do you
one
recall-
of the sheriffs.
I'm sorry. I didn't-
Or one of the sheriffs.
Oh. And did you do any follow-up information once you received the subpoena? Like, for example, sorry. For example, calling the district attorney's office?
I did not call the district attorney's office. I did reach out to the clerk's office to see if there was any further information.
Were you or your daughter injured in any way during this incident?
No, we were not.
No further questions at this time.
Thank you. Any cross?
Yes, Your Honor, thank you. Good morning, Mr. Kohler.
Good morning.
Thank you for being here. To be clear, sir, the subpoena you received was issued on behalf of the defendant, Darrell Brooks, correct?
I don't know. That information was not filled out on the subpoena.
Okay. You did provide a typed statement to the Waukesha Police Department, correct?
Objection, leading.
And
Overruled. Oh, if there's an objection, let me rule on it first before you answer. Overruled, go ahead. And his answer, I believe he answered it, but if not, did you answer it?
I'll ask again.
Thank you.
You did provide a written statement to the police department, correct, sir?
Objection leading.
Overruled, it's cross. 90611 sub 2.
Yes, I provided a written statement.
And in that statement, you described the SUV as driving erratically down White Rock Avenue, correct?
Objection. Didn't testify to that. That was asked and answered.
Overruled, the witness may answer. And it's sub 3, not sub 2, by the way. Go ahead.
Yes, just the event of driving past some participants on the right and then veering to pass a next group on the left.
Okay. You said at that point, when the vehicle was on White Rock, it was honking its horn, correct?
Correct?
There was no objection. You can answer.
And you saw an officer run up and try and open the door to the vehicle, correct?
I don't know that he was trying to open the door, just trying to, I don't know what he was trying to do. He ran and his arm had gone towards the door handle.
Okay. And that was at the intersection of White Rock and Main Street, correct, sir?
Yes.
And you got a look at the driver of the car, correct, sir?
Objection speculative.
Overruled, the witness may answer.
Yes, I did.
And you described the driver in your written statement as a black male with dark dreadlocks and visible tattoos. Is that correct, sir?
Objection leading.
Overruled, the witness may answer.
Yes.
Is that consistent with your memory, sir?
Objection speculative.
Overruled.
That is consistent with my memory today.
Once the vehicle went past the officer, you indicated that you saw it accelerate or speed off. Is that correct, sir?
Objection leading.
Overruled, 90611 sub 3.
Yes, at that point, it sped away.
Thank you, sir. I don't have any other questions.
Any redirect?
Briefly.
Go ahead.
Referring to the written statement that was just testified to the best of your recollection, do you recall stating that the SUV was a older model red Chevy Blazer?
I do recall putting that down at the time, but that was at that addition that I added 2 weeks later.
So at that time, during the evening of the incident, to the best of your knowledge, that would have been your opinion of the vehicle that you saw?
At the time of that, the day of the parade, I just remembered the red SUV.
To the best of your recollection, what assumption will lead you to describe the vehicle as a Chevy Blazer?
I believe in my assumption it was just to say it was a older boxy style SUV, and in my mind that relates closely to a Chevy Blazer.
No further questions.
All right, thank you. You may step down. And you also are excused. Thank you for being here. You may call your next witness.
Thank you, sir.
One second. If I may have just a quick second.
Go ahead.
The defense will call Stephen Guth.
I believe one of my assistants went to retrieve Detective Guth, Your Honor.
Thank you.
Check into the stream, everybody. Comment where you're watching from. You're watching the State of Wisconsin versus Darrell Brooks morning session. Darrell Brooks is the defendant, and he is also representing himself, so he gets to play the role as a lawyer. And call witnesses. So the state rested its case yesterday, and now we're on Darrell Brooks's case.
Right, good morning. Detective Guth, if you would, as you are, come to the witness stand, remain standing, raise your right hand, and my clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Please state your first and last name for the record, or names, I should say.
Stephen Guth, Stevenguth.
Go ahead, sir. You're witness.
How long have you been in law enforcement?
Over 20 years.
And how long have you been a detective?
Just over 7 years.
Directing your attention to the evening of November 21st of 2021. Do you recall that evening?
I do.
And were you on duty that evening?
Not initially.
For more clarification, what do you mean by not initially?
It was a regular off day for me, but I received notification to respond to the police department for the mass casualty incident in the downtown area of Waukesha.
So at that point, I'm assuming you were dispatched to that location?
I was not dispatched. I received a Signal message. We use Signal. It's an app that's used that we can share information for investigations. And I received a Signal message that this tragedy just happened.
And so what did you do from that point?
I immediately dropped my wife and kids off and responded to the parade.
And when you got to the parade, what did you do at that point?
I went to the downtown area to assess and see what I could help with.
At some point during your investigation, did you make contact with a woman by the name of Erica Patterson?
Yes.
And what was the nature of that that part of your investigation?
I wanted to speak with Erica Patterson because by that point, when I made contact with our command center, they had learned the name of Darrell Brooks and had learned that Erica Patterson was the estranged girlfriend of the suspect of this investigation.
You made reference to estranged girlfriend. What do you mean?
I don't know if I should answer that.
I think the question was pertaining to the word estranged, but we'll move on.
The jury will disregard that last question, that it's been withdrawn. And the statement made by Detective Guth following that.
I'm assuming at some point you took a statement from Ms. Patterson?
I did.
Do you recall if it was recorded, written, you writing it? What was the nature of how the report was taken?
Estranged girl. Well, her words were spoken and they were recorded, and then I prepared a report.
Did you prepare the report that same evening?
No.
When did you prepare the report?
Sometime after the 22nd of November.
Why not the same evening?
Because after I spoke with her, I wanted to go back and speak with her again.
Did you obtain any statements from any other people that may have been involved with Ms. Patterson?
I did not.
Do you know, to your recollection, if any other officers have taken statements from parties that may have been involved with Ms. Patterson?
Well, the night of November 21st, 2021, I did have a partner with me, another detective.
Do you recall him talking to any other parties that may have been involved with Ms. Patterson?
Well, the detective that was with me was a female, Detective Barron.
The question was, do you know if your partner had any interactions with parties that may have been involved with Ms. Patterson?
I don't believe so.
Hold on,
but
are
I
you
can't-
specifically referring to a date certain or just in general?
I think it was clear.
I need it clear for the record,
The
though.
date would be
On the
November
21st?
21st
Okay,
of 2021.
thank you with that clarification.
No, I don't believe so.
Did you learn at any point that there may have been other parties involved with Ms. Patterson?
In which incident?
I'm referring again to November 21st of 2021.
Yes.
Do you recall who those parties were?
Corey Runkle and Nicholas Kirby.
Did you yourself speak with either of those parties, Nicholas Kirby or Corey Runkle?
No, I did not.
Do you recall if your partner spoke with any of those parties?
Which partner?
I'm guessing the female partner that you made reference to.
No, she did not.
And in that recorded interview with Ms. Patterson, what did you learn about the evening of November 21st, 2021?
Which recording?
Are there multiple recordings?
Yes.
What did you learn about the evening of November 21st, 2021 from both recordings with Ms. Patterson?
Your Honor, I'm going to object at this point, as this testimony covers ground that was very clearly covered during the state's case in chief.
I'll give Mr. Brooks some leeway. You are asking for hearsay, though, you understand that.
I asked him, what did he learn?
Fair enough. Go ahead, you may answer.
I learned several things. Initially, I think is what you were getting at. Ms. Brooks wanted to report that she was injured by Darrell Brooks on November 20th, which would have been Saturday. She stated that she met with Mr. Brooks at Frame Park, and they were arguing over the fact that she did not give him money, and he injured her by slapping her in the mouth and punching her in the eye. The next day, I went back and talked to her again, and she clarified that that actually did not happen on the 20th. It happened on the 21st, and that she got in a motor vehicle with him over the same argument. He was mad that she did not provide him with money. He proceeded to try to take her phone because he thought she was talking to other guys. Slapped her in the mouth, punched her in the eye. She jumped out of the motor vehicle because she feared for her safety and made her way back towards Frame Park. While walking back towards Frame Park, she was calling her friends, Corey Runkle and Nicholas Kirby, to come help her. When she arrived back near Frame Park in front of White Rock School, there was a confrontation in front of White Rock School with Mr. Brooks, Erica Patterson, Corey Runkle, and Nicholas Kirby, where there was some kind of shoving match. And that's when Mr. Brooks got back into the motor vehicle and took off down White Rock towards Main Street. Erica Patterson then made her way back towards the Women's Center.
You made reference to being told about an incident from Saturday, November 20th. And then stating that in the second interview, Ms. Patterson stated that didn't happen. Is that correct?
She didn't state that it didn't happen. She just stated that she didn't drive around with him on Saturday, November 20th. But she also met with him and was slapped in the mouth that day too.
If it pleases the court, I have a document here I would like to show the witness.
All right, if the bailiff could have it to the state first to look at it. We may use the document camera if that's hooked up.
How
Otherwise,
is
the bailiff
everybody
will
doing?
Take it to the witness.
We're watching the state of
Before we
Wisconsin.
go through that process, I'm going to object. It's, well, maybe
Let
we
me
should
see the
talk about
document.
this. Yeah.
State of Wisconsin versus Darrell Brooks. Hope everybody's having a fantastic Friday. You're watching this live here on Friday, October 21st on Facebook and YouTube on Mercado Media.
All right, and give that back to Mr. Brooks. Given the content of that document, I'll sustain the objection, or what that document is, I should say.
Sustain on what grounds?
It's not relevant, yep, to this witness's testimony.
How is it not relevant?
It's not relevant.
He made reference to November 20th. That's what this document is talking about.
It's not relevant to the charges at issue. We can take it up later, and if need be, I'll let you recall the witness, but I'm directing you to move on to a new topic.
Your Honor, I'm going to respectfully object to that and ask for a finding of fact.
The objection's noted, it's sustained. Well, their objection's sustained, yours is overruled. Please continue.
Is that noted for the record? I would like a written finding of fact.
The request is denied. Keep going, please.
Denied on what grounds, on what lawful law?
Keep going, sir. It's not relevant.
Are you making a judicial determination that you don't have to answer that question as a public servant?
Sir, I've ruled on the objection. It's on the record. Please keep going.
Once again, information that needs to be known is being hidden.
It's not relevant, sir. Please
It's
continue.
very relevant. He just opened the door on that by saying November 20th.
Objection. Move to strike all of the comments made by Mr. Brooks in the last 20 seconds or so, especially with regard to any implication that he hasn't had all of the discovery material.
Objection, I never made any
Alright,
mention of not having any discovery material. That never
The
was
jury will
stated.
just disregard, as I've told the jury repeatedly, comments made or statements made by the parties, whether they be lawyers or the parties themselves, are not evidence, and you're to disregard them and not consider them in any way. And if the statement suggested facts that are not in evidence, you should not consider that in any way either. All right, go ahead. Your next question, please.
So is it fair to say that in your report you referenced 2 incident reports?
Objection. This
Grounds.
witness wrote.
I'm going to overrule
Fine.
the objection and let the witness answer it. I think it might just be semantics at this point, but go ahead and ask your
What do you
question.
mean semantics?
I think you were referring to that he had 2.
That's what his report says. He makes reference to two reports, 2 incidents.
2 incidents.
Yes.
Not 2 incident reports. Reports would be separate documents. That's what I'm talking about. With that understanding that you're referring to, and I think you're referring to incidents with Ms. Patterson, correct?
Yes.
Go ahead. Ask your question. I think that clarifies so that the witness can answer.
In your, let me back up. You wrote your own report. Would that be fair to say?
Yes.
And in your report, you referred to 2 incidents. Would that be fair to say?
Just to clarify, which report are you speaking about? I wrote several reports.
The one written November 22nd of 2021.
I do reference 2 reports and 1 CAD call.
What was the last part? Cat call?
A CAD call, yes.
What do you mean cab call?
Not cab, CAD.
Cat.
C-A-D.
Cat.
A CAD call.
What do you mean cat call? What?
That's a call for service that does not generate a police report.
And what was that cat call?
That was a call for service near Frame Park for a fight involving potentially a domestic related incident.
Do you recall any other details about that CAD call?
There wasn't much in it because the officer had to leave to go to the parade.
Do you recall a mention of a knife during that CAD call?
Yes.
To the best of your recollection, do you recall anyone recovering a knife or you yourself recovering a knife?
There was no knife involved in that incident through my investigation of the report that you have.
But it is fair to say that that's how the CAD call went out, that there was potentially a knife fight.
That's how it was initially, I believe, reported or communicated through dispatch to the officers that responded.
You made reference, and I'm referring to the second interview with Ms. Patterson. You made reference in your report that in the previous interview that Ms. Patterson was not completely forthright. What exactly do you mean by not completely forthright?
She did not give me all the details of the incidents to me initially.
Do you recall why?
I don't know why she didn't.
So it'd be fair to say that Ms. Patterson had been untruthful with you in the first interview.
No, she told me she was extremely afraid of you. And that's why she didn't want to tell me everything.
Well, you just stated that you didn't know why she was not forthright.
I can't read her mind, but that's what she told me.
Gonna get himself in more trouble. Open the door, Mr. Brooks. Ho, Bulldodge, thank you so much for joining the YouTube channel. Mr. Brooks is gonna open the door.
At any time during your investigation in regards to the incidents with Ms. Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them?
Had you seen any statements made by those two parties?
No.
Would it be fair to say, assuming that those two parties were present for the incident on the evening of November 21st of 2021, would it be fair to say that at some point they were interviewed by law enforcement officers, to your recollection?
Yes.
And you've never seen any of those interviews?
They weren't video recorded.
Had you seen any written statements from them or report from law enforcement?
I received a summary of what they stated verbally from another detective, yes.
So it'd be fair to say you did have knowledge of what they said transpired on November 21st of 2021.
I had knowledge of what they said. I didn't see anything. Correct.
And to the best of your recollection, seeing what those two parties had said, what do you recall?
Objection.
Grounds.
The evidence, you didn't see what they said, and also calls for hearsay.
Sustained.
What did you read
Objection.
from those statements given by those two parties?
Objection. Calls for hearsay.
Grounds.
Sustained.
Grounds for the sustain.
Calls for hearsay.
One second. Do you recall what officer took those statements from Nicholas Kirby and Corey Runkle in relation to the incident on November 21st of 2021?
Yes. Yes.
And what law enforcement officer was that?
Detective Van Els.
And after that report that you wrote on November 22nd of 2021, was that the end of your investigation into the incident of November 21st of 2021?
No.
And what was the extent of your investigation after November 22nd of 2021?
Judge, I'm going to object. Well, on the defendant's behalf, I believe here, based on some previous rulings the court has made.
Sustained.
And did you speak with Ms. Patterson again after filing your report?
Yes.
In reference to the incident from November 21st of 2021?
I don't understand your question.
Did you speak with Ms. Patterson after you filed your report in relation to the incident from November 21st of 2021?
No.
In relation to the alleged incident on November 20th of 2021, do you know if that alleged incident ever took place?
Objection.
Grounds.
Calls for hearsay, lack of personal knowledge.
Well, he reported it.
It also goes to one of the ultimate issues that the jury will need to determine, so it's sustained.
Questions? No further questions right now at this time.
All right, thank you. Any cross?
No, Your Honor.
All right, thank you, sir. You may step down.
May have something later for that particular witness.
All right, I'll try to raise that on an appropriate break. Call your next witness, please.
Is there only one witness left?
Yes. For that, yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
Who's supposed to come in 10:30, right?
Call your next witness, please. I don't have that list right at my fingertips.
You said what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
Does the state have that? You could pass it over. I don't have that at my fingertips.
Sure, let me try to, I have it, but I'll write it up for Mr. Brooks to review, Your Honor.
Thank you. While we're doing that, if the jurors want to stand for a minute, go ahead, or anyone else in the courtroom.
Hey everybody, I have to run an errand to help one of my family members, but I'm gonna keep the feed running. So it's likely gonna go through the break. So break time, you might just be looking at the clock instead of some old footage, which is okay. So expect during the morning break time just to be looking at the 10 minutes of the clock that they put on the screen, and then I'll be back again right after that. I shouldn't be too long, but I'm gonna have to step away from the computer for a bit while we're covering this trial. Like the video, make sure you subscribe to the channel, behave. The mods are gonna be here looking at the chats, and I'll be back as soon as I can. Again, we're not ending the stream, not going anywhere. I'm just likely not gonna be able to replay old footage and talk about the trial just for the morning break. I'll be back for the lunch break and we'll do old footage again, and then in the afternoon, I'll be able to do the old footage during the afternoon break as well.
I accept for value in return for value this paperwork.
Thank you. If everyone would have a seat then. Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. There's a witness available. Please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 906.11, I have the authority and the discretion on that, so please call the witness who's available.
So I'm being rushed to jail.
No, sir, I'm trying to have an effective and efficient use of all of our time. So please call the witness.
Which is respected, but at the same time, being that this is my time
Right,
to
I'm going to
present my
excuse the
defense.
jury for right now. I'll rise for the jury, please. All right, thank you. Be seated. Mr. Brooks, under 906.11, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So
no. You
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her.
Yeah,
She's
the
on
re-
your list. She was on the listing, as I understand it, with the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here, she's ready to go,
I'm just
she's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of witnesses.
why is it always so hard to just say yes or no?
Yes,
Is it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if
told
you
me
don't want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
You told
fine.
me your
Your
authority.
objection
I'm
is
not
noted
debating
on the
your
record.
authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I said I had with the
You
last?
said you wanted to raise
said-
an issue with about
What
Detective
I
Guthrie
said was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard what I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted, and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses, my subpoenas.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that
And
from the
so then
beginning.
I asked
Your
you
Honor,
to put
with
him
all
in
respect,
blocks.
with all respect, did I not inform Your Honor and the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I
times.
have authority to tell you otherwise. You
I
may
did-
not like it. You
I
may
did.
disagree with
It's
it.
not
You
about
have
that.
been-
It's about the rush
you
to
have not
judgment,
been
Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never
And
asked them to
frankly,
do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I or did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of the day,
but we expect
if
your
they didn't want to do
cooperation in
it,
that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
because
normal
if you
in a trial
you can't
to call
put the people
witnesses
you can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the
saying
state
that, sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be
do it.
provided with. We're going to call this witness at this time,
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
Here's the
with a
situation.
shock device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm
I
having
just
to-
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If
You-
I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how
of
that's
the
fair.
process that has been set up to frankly help you. Get
No,
the
it's
witnesses
not helping me by
to
it's helping
court.
the state
And no.
by being able to say if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them
yesterday-
my witness list.
Yesterday,
It's not my fault.
I very
It's not my fault they
expressly-
weren't going to be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this.
I'm going to
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
I'm not
don't
going to be
call her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You have
witnesses.
to cooperate with this process.
But I
sir.
also have the Sixth Amendment
We
right.
have a witness available for you to call. I can require
It's
you
not
to
the witness
call her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or of
I'm not going to
or
play
order.
this game with you, sir.
It's not no game. That's
It
what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take this as a
asked-
game. That's what
me explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question-
This is not a game to me, Your Honor. Nothing about this is a joke.
I never.
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So,
And I
so I
understand.
think, Your Honor, with all due respect, I think you should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
Record after a short break. Appearances are as they were before. I would just note Attorney Opper's not at the table, but I presume she'll be back shortly. I will be advising the clerk to have the jurors brought out, and then I'll ask you, sir, to call the defense next witness.
Can we address subject matter jurisdiction and still has to be proven for the record?
I decline to do so. Your objection is noted for
Is
the
the
record.
audio on?
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir. It's on.
So we're not going to address subject matter jurisdiction that has yet to be proven for the record?
For the record, I have addressed it.
No, you haven't
And
proven it
there's
for
a
the
written,
record.
and your objection's noted for the
Have
record.
you proven subject matter jurisdiction for the record? Have you proven it? Has the prosecution proven it?
Oh, okay. Email that to her and print it out.
So that's a judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
Give me 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment. That's not right. Oh, there you go. All right.
Go ahead.
Defense calls Erica Patterson.
All right, thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
Oh, you wasn't spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ErikaPatterson.
Just 1 second, Your Honor. I'm trying to find some. relevant paperwork here. One second. I'm sorry about that. 1 second, I'm trying to find this paperwork. Just had it on the table.
When you're ready.
This paperwork.
Did you print that off for me? Did you email it to me?
It's still not here. What's your name? Did you spell?
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason. Good morning, Miss Patterson.
Good morning.
So, what do you do for a living?
I have my CNA certificate.
I'm gonna direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
I was hanging out
I
with
think
Miss
that kind
Corey.
of got a little ahead of.
Mr. Brooks, just, I'll let you interrupt the answer and you can ask a follow-up. I apologize, I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021 before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection and grounds for, I object to that and grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
the
what the-
objection is from the state is overruled. Do you remember the question?
You asked me what we were doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Is that usually the name you refer to the alleged defendant by?
Nope.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park, and she went her other way with her friend.
Do you recall who that friend was?
Nick.
I'm assuming, or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this is a street, it's like a hill. Went up there, and then me and you got into an altercation. I got out of the car. walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering
Okay.
your question.
Um,
You asked her where you drove from. Go ahead,
What?
finish.
yes, ma'am. And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was I walked back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there was something going on.
And did you ever arrive back at Frame Park?
Yes.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back across the street, and by that time, Miss Corey had already walked towards us to meet up with me.
And you made reference to you calling your friends.
Mm-hmm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone. Her phone kept going to voicemail, so then I called Nick's phone. He put Corey on the phone. I said Darrell Brooks had just hit me.
I want to back up a little bit, if I may, to the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. I went to Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went her a different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
Funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection. Move to strike the answer and the question.
Grounds.
Lack of personal knowledge. Hearsay.
Sustained. I'll strike the question and the answer for the reason stated, sir, rephrase, or...
So can I show the witness that same paperwork that I attempted to show?
No.
And why not?
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No. Next question.
Any reason why it would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Some facts not in evidence. Sustained.
Grounds for the sustain.
The record speaks for itself.
So, upon speaking to Detective Goof during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright, I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. I told him the next day, Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, both like little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
So where were you injured?
By my lip?
Objection. This states the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents
I
from
don't know.
November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
One second. So what time did you meet up with the alleged defendant on November 20th, 2021?
I don't remember.
Was it morning time? evening
Afternoon.
time? I didn't hear that.
Afternoon.
And what were you doing prior to the alleged meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Next question, please.
When was it answered? So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Seems facts not in evidence. Mischaracterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air. Interesting. So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes.
Yeah, is that the only child in common?
Yes.
You have any other children?
Objection.
There's
Grounds.
nothing to do with the case. Sorry.
Hold
Mr.
on,
Your
there's
Honor.
been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant? child that you have in common with the alleged defendant, how old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained.
Grounds.
It's not relevant, sir.
She answered it.
Next question, please.
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds.
Relevance.
Grounds.
Sustained, not relevant. You don't have to answer that.
Thank you.
Do any of your children live with you?
Objection.
Grounds.
Relevance.
Sustained.
Grounds for the sustain?
Not relevant.
That goes to the credibility, Your Honor, so how is it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record, I direct your attention to 906.16, and the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Is that lawful law?
Next question, please, sir.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay. Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I don't remember.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming, that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. That's not proper procedure, sir.
I'm going to object to those being shown to the witness. They have no relevance whatsoever to this trial.
Yes, they do. And I'll get into how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustained why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Assumes fact, not in evidence.
Grounds.
Sustained. Assumes facts not in evidence. Not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence.
No,
And at
facts.
this point,
I got the pictures right here.
after
Facts.
the alleged date of violation here is not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. I'll rise for the jury. Thank you. Be seated.
That's awful funny. Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter
hold
too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you
Sir,
need to have
do you want
contact?
to open up the door to the other act's evidence of
That's
you?
not opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. But when did you receive the document?
Okay, but I just want to stay for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the evidence.
That is true.
No,
she said it herself.
No, marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want the letter?
I want to see the letter.
What?
I want to see the letter.
Okay, so I got.
And I want to know when you received it.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I want you to make a record.
Procedure.
If you don't make a record, then I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop
even
it. You're a public servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what he's referring to in count 77. Okay.
And what happened to that paper? Because it was on the table. Then when I come back in,
I need to make a record of a variety of things.
So who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
okay,
sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, She did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now
find
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I will have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like,
I
well,
don't
that's
think
kind
that's
of
fair.
interesting.
I
I
don't
don't
think
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said,
effect.
but I did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. And you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't. I referred to this one because this one had the pictures. But
And why do you
the
believe
one,
it was from
to
Ms.
answer your
Patterson?
question, to answer your question with clarity,
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter. I brought the pictures because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need
knows
the
that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing in jail. Oh, this and this and that. Oh,
I don't think
no, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that. But I don't believe she
But
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate
Honor.
to her credibility before the
Who
jury?
else could these pictures be from?
I'm going to ask you point blank, did you get a letter that's signed from her?
I got. What do you mean signed? No
How
one
do you
signs
know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding me?
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna. When you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like,
that.
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How
Okay.
many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. and I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we
assumes,
can hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic
because
to try to
it's not a
go
tactic.
off
It's
of what
facts.
we're talking
It's facts.
about to some other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe it's.
I didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the
finish.
end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me
disrespectful,
she was when we
interrupting.
met. We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter
Dog
and he
gonna
can
sit
show
there and try
it
to
is
think he knows
inadmissible,
what's
she
going
will
on.
not be questioned. And under 906.11, I will
Then you gonna
declare
talk
the
about where my kids
cross-examination
live. You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
The jury brought.
All right, I'm here. We're here. I was not expecting an early lunch, so I apologize for that. But holy shit. We got to go back and see that. I was sorry about that. I was not expecting the early lunch break. But let's replay that whole segment. I just ran up the stairs into my apartment, so I'm out of breath. I ran. Doors open though, so let's rewatch that segment. I'm Andy Mercado from Mercado Media. We're here still. I'm live. I apologize. I got my errands done. Woo, I'm out of breath. I just ran up 3 flights of stairs in 0.2 seconds. My goodness. So I apologize for that. Here we are. Here's the replay of that whole segment, starting from about 20 minutes, starting now.
I'm going to excuse the jury. I'll rise for the jury.
Judge said an hour lunch break, correct?
seated.
That's awful funny. Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter
hold
too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document?
He doesn't have the letter. And he's gonna go back. He's gonna whip up something. Watch. I bet he might whip up a letter. We'll see. But he doesn't have a letter.
So hold on. I'm having you make an offer. But when did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the evidence.
That is true.
No.
She said it herself.
No. Marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this,
you,
and I'm going to give you the
fair.
opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want the
letter?
I want
to see the letter.
Did you want a finding for a fact for a lawful law?
What?
I want to see
That's some shit he says.
Letter.
Okay, so I got.
And I want to know when you received it.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and
Okay,
I want you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
He had to plan this out in his jail cell last night. He said, "Oh, the state can pull out some evidence on the fly," which they didn't, by the way. Again, he had the evidence that they had brought up yesterday, which was his music video, and that's in his boxes, and that was already presented to the court that they were going to use that if he opened the door, which he has opened the door to more evidence every single witness. So, he was in his jail cell hyping himself up last night. Hell yeah, they brought out that evidence. I'm going to hit him with this one. And knowing and he's an idiot, so he didn't expect them to have him present this letter, and so he goes off of his own word, which is obviously not good in a courtroom.
People off the loop, they weren't ready for it, they scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
it.
even
Stop it.
letting
You're a
me
public
ask the
servant, Your
question.
Honor. I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated.
She had visions of life without possibility of parole playing in her brain when he started clapping, for sure. And in that moment, she's like, "Damn, I wish Wisconsin had the death penalty." Probably. She's
So
done.
yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay.
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
Oh God.
The
He
doc.
needs to constantly have the last word, and again, she's being very careful so she doesn't. He's trying to get under her skin, and she's trying to be very careful with how she handles it, because he's trying any avenue to try to get a mistrial on appeal.
Document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess
Your Honor,
is maybe
with
to
all respect.
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Because that's an abuser tactic when they say, well, there was no physical marks or anything on them when they're abusing their victims. So they knew that he was going to pull that card, and he is. So they're literally, they must know this guy's brain, because they have plugged up every avenue he's tried this entire time, and they're doing a damn good job of it.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
I tried, yeah, and I've been trying to find it ever since I came back in here, and now all of a sudden I can't.
And now
find
you're
it.
impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Miss Patterson.
And they knew, and I saw comments too while I was away, that they knew, the chat even knows, that he was playing games with her. They're on top of him. They're on top of his ass for his games.
And if
They just need to let him, unfortunately, they need to let him play some of them, so that way they don't the court doesn't get out of order and the judge says something that he can use during his appeal for mistrial.
I will have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like, well, that's kind of interesting. I don't have a document that was just on my table. That is what you said.
That's what I said, but I did not point the finger at anyone.
So,
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction.
Gaslight, right? Try to say what I didn't do this, I meant something else, right? Or while I'm doing something, it's like imagine somebody hitting you and then they're saying you're making me do this type thing, like, right? Or that's just an example, but he's gaslighting with that, saying that, oh, I'm not. And the other constant one he does is, I'm not disrupting the court, I'm not interrupting the court, with all due respect. It's all a gaslighting tactic.
Away from what we're doing, perhaps even to stall and to delay.
Mm-hmm. I'm sorry.
That's my that I'm making.
I'm sorry you feel that way. Another comment. He is just he's 40 years old, so he hasn't been checked for most of his adult life, or half of it at least. I mean, well, he's done now, but life expectancy for adult male, you know what I mean? He's half of his life he's gone unchecked with this boss level of narcissism and manipulation tactics that he's just carried through his entire life. And this is what it looks like as an adult. They look like a grown man child, baby.
You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't. I referred to this one
There's no letter.
because this one had the pictures. But
And why do you
the
believe
one,
it was from
to
Ms.
answer your
Patterson?
question, to answer your question with clarity,
Thank you.
Hand out, another tactic too.
Thank you. Does it have a date on it? The letter?
no, I didn't
Hell
bring
nah.
the letter. I brought the pictures because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need
knows
the
that they
letter.
sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that.
I don't think
no,
she's
I still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that. But I don't believe she
But
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she
It was
said,
why.
I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate
Honor.
to her credibility before the
Who
jury?
else could it be? Who else could these pictures be from?
I'm going to ask you point blank, did you get a letter that's signed from her?
I got. What do you mean signed? No
How
one
do you know?
signs letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question.
This is literally like when a child is lying to you. Like this is I'm sure some of y'all have kids and your kids tell some lies. And this is like almost the exact way like a middle schooler would tell a lie to you, like straight to your face.
Why do you believe the letters are from Erica Patterson?
Like facial reactions and all, body language, everything.
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna. When you
You're
say
not
to
answering
me,
my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why would
lay
I
a
not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like, how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
Miss Patterson is his ex-girlfriend who he called as a witness to take the stand.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So when we I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
No letter. He's going to come back with nothing. Or if he does come back with something, it's going to be some forged ass forgery.
Do you have the letter with you in court?
Oh, it's about to get worse. If you miss this, it's going to get worse here in like a couple minutes.
Said no. How
Okay.
many times I got to say the same thing on record?
What's in the letter is in his hand. He had looks like baby photos. It looks like brand new newborn baby photos of his kids, allegedly.
You know, sometimes, sir, I don't hear
Because again, we have no idea where those photos came from.
what you say because you interrupt me so much, or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
you tried
it's
to
not
go
a tactic,
off
it's
of what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe it's.
I didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
All right.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object
Let
to
the
that.
state make their argument without interruption, sir.
That's a lie, though.
Mom sent him the pictures.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
Oof.
And that's
Furthermore,
I object to that
kill shots.
because that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
The real Brooks is here, everybody. The real one just about to show his face.
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
no,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he
Don't
can
sit
show
there and try
it
to
is
think he knows what's
inadmissible,
going
she will
on.
not be questioned. And under 906.11, I will
Then you gonna
declare
talk
the
about where my
cross-examination
kids live. You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time when
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
So not only is he a mass murderer, but he's a predator as well. Because he impregnated the mom of his child when she was 14 years old. Okay, just to give you that concept. So he's a predator as well, convicted in Nevada. And again, this is his rap sheet that the witness yesterday, Nicholas, was talking about. That's the rap sheet that he had seen. So again, they've tried to avoid all that. The jury didn't hear that, right? The jury didn't hear that. We did. We all heard it. Let's pick up with some witness testimony from this morning. And again, we'll be back. I'm not going to end the court feed at all. It's going to be 26 minutes. We should be back from our lunch. Facebook, though, and Facebook only, I will be ending the Facebook stream just because I don't know how long the afternoon sessions go. One night it went till 6 o'clock. 2 days ago, it just went till 6. Yesterday, it wasn't as late, but Facebook, I'll be ending it right before lunch break ends. And starting a brand new one. YouTube, you don't have to go anywhere. The same stream is going to be running all day long for 8.5 hours or whatever. So just Facebook only. I have to split the stream into 2 segments because I'm limited to only 8 hours on Facebook. Whereas YouTube, I think you can have an infinite stream forever and ever and ever and ever. All right. So let's go back to some morning testimony. We only have about 25 minutes left, and we're going to get back and see if he returns with a letter, which again, he won't because the pictures came from his mother. Like the video if you haven't. Make sure you're following us on Facebook. Again, yes, especially if you haven't followed yet, make sure you're following and notification bell on, or just go back to my page and refresh until you see the stream. But it'll be pretty quick. It'll only be about a couple seconds in between when the stream ends and when a new stream starts for the afternoon session.
Zach, can you help Jen? I think she wants help on that message.
Thank you, everyone. Please be seated. Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that. Thank you. All right, go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kohler.
All right. Good morning, sir. If you would please make your way to the witness stand, which is up toward me, up one riser, and to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Douglas Kolar, Douglas Kolar.
Thank you. Go ahead, your witness.
Good morning, Mr. Is it Kolar?
Kolar.
Kolar. Good morning, Mr. Kolar. I want to direct your attention to November 21st of 2021.
Hold on. Someone said hold on. Let's go to Twitter quick. I'm reading some comments. Again, this is some old testimony from this morning anyway. So let's go to Twitter. Someone said go to Twitter and type in MathBoyFly. Hold on. Where's the one you're talking about? I seen the one someone said that he talked about it. No, hey, send the link to the Discord server in the videos in the trial discussion. Send the video you're talking about where he discusses where he knows about it. Okay, yeah, I'm not getting anything here. Maybe let's see top. Hold on. Send if you know what video it is, go to my Discord server and send it there, and I'll play it once it comes up.
Do you recall that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time. Directing your attention back to the night of November, evening of November 21st, 2021. What did you do that day?
Well, that day, I was preparing my daughter to march in the parade with her dance troupe. Watched football earlier in the day and got her dressed, and we had to change our plans last minute because my son was not feeling well. So it was just my daughter and I that went to the parade.
And do you recall what time you arrived at the parade?
It was at least an hour before the start time of the parade.
And do you recall where you were positioned at in the parade?
I moved with the dance troupe, so I
kind of going with the flow.
Correct.
And at some point you observed something happening. Would that be fair to say?
Yes.
Do you recall what that was?
Well, after my daughter had finished and I was walking back to our vehicle to go home, I noticed as we were approaching White Rock, which is what we were parked off of, I noticed a vehicle coming through where the parade participants were going. It was a red vehicle. It was honking its horn. It passed a few parade entries on the right-hand side, and then it passed between two of the groups. It veered to the left and went around the next group on the left-hand side, at which point a police officer attempted to approach the vehicle. That police officer had reached for the door handle, and at the time of that approach, the vehicle started to speed off.
I just want to back up just a little bit. You stated that you heard the vehicle honking its horn.
While it was on White Rock Avenue, it was honking its horn.
In your opinion, did the vehicle appear to try to avoid hitting people?
At that point, yes.
And you made reference to it the vehicle coming in contact with an officer. Did you see where the vehicle went after that?
So this testimony and the next testimony is more of the same. They're very quick, and he doesn't really get to the bottom of anything. So we're having some people saying that they missed Erica Patterson's testimony. So we'll start there. It was right after the morning break. So I'm just going to skip forward to where Erica Patterson's testimony begins, just in case you missed that, because that was right after the morning break. So let's hear. Here's that testimony.
I have to answer that, Your Honor, being a public servant.
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
Give me 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment. That's not right. Oh, there you go.
Sitting here trying to figure out what questions he's gonna ask while he's digging through paperwork.
All right.
Go ahead.
Defense calls Erica Patterson.
Great, thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Does he even know what he's got going on with his papers? Likely not.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my coach, Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated. First thing I will ask you to do.
Real quick, we got the clip. Hold on. It's from TikTok, apparently. Real quick. So this is him.
But then it's like reality set in. You actually become the drug. Not even a human being. Basically. That's how I felt. Like I wasn't a human anymore. I was just something vile, disgusting, despicable. I could go on. I could use a lot of words, but that's what I became. It's really what I became.
What was this? Okay, well that was nothing. All right. I don't know what that clip was.
You is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
I wasn't spelling the name.
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ErikaPatterson.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here.
Send to our Discord server. I can't pull up Messenger right now. Discord is what I use for all links.
When you're ready.
Link to Discord's in the description. I'll post the link right now.
Did you print that off for me? Did you email it to me? It's still not here. I'm like, what's your name? Did you find it?
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason.
And that's what the judge said first time, that he was implying that someone had messed with his paperwork because he's doing that. Some reason why these papers are gone. It's not me, because again, he's never going to take accountability for literally anything other than, I mean, he was just shuffling his papers around all over his desk for about 3 minutes prior to this, but you know, it's someone else's problem.
Good morning, Miss Patterson.
Good morning.
So what do you do for a living?
I have my CNA certificate.
I'm going to direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
I was hanging out with
I think
Miss
I kind of
Corey.
got a little ahead of...
Oh. Mr. Brooks, just, I'll let you interrupt the answer and you can ask a follow-up. I apologize, I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021 before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection and grounds for, I object to that and grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
the
what the
objection is from the state is overruled. Do you remember the question?
You asked me what was I doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's Hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Is that usually the name you refer to the alleged defendant by?
Nope.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park.
Oh, real quick. We got the video here. Hold on. Oops.
Ten years ago, 2006, I caught a case with my oldest daughter's mama. Yes, my baby mama. She's from Oakland. I was busting moves in Nevada. I meet the say she want to get down, so I'm pimping on the I'll take her to Nevada. You know what I'm saying? I get cracked. You know what I'm saying? I didn't know the was 16 at the time. She gave a statement to the police and told them, yeah, she was and that I was in and that she was 16 and that I didn't know that. Okay?
Wow. Well, that's the video. I'll play that again during the afternoon break because there's some people that are gone right now. But wow, that's the video everyone was talking about. That's Brooks talking about talking about Erica Patterson when she was underage.
And she went her other way with her friend.
Do you recall who that friend was?
Nick.
I'm assuming, or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up?
Yes.
Well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this is a street, it's like a hill. Went up there. And then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering
Okay.
your question.
Um,
You asked her where you drove from. Go ahead.
and
Finish.
then, yes, ma'am. And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was I walked back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park.
Oh, many people like him exist, Anna. Many people do.
When I got to Frame Park after I left it, that's when I realized there's something going on.
You realize he's had a long criminal record prior to this. This is just the final destination for someone like this.
And did you ever arrive back at Frame Park?
Yes.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back across the street, and by that time, Miss Corey had already walked toward us to meet up with me.
And you made reference to you calling your friends.
Mm-hmm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to?
So they should be returning any minute now. I'm live right now talking to y'all. This is still the morning session stream, but the court is not live yet. The live video is on the right side of your screen underneath jury and recess. So that's actually the live video. So as soon as I see that change and the video court feed is back on, I'm going to be ending the Facebook stream and starting a brand new one. Okay. Because again, I'm limited to only 8 hours a day on Facebook, or excuse me, 8 hours a stream. And sometimes the streams go 8.5, 9 hours. So just to make sure Facebook doesn't miss anything, I just end it right. It's just going to be a quick 3 to 5 seconds of ending, and then I'm going to start it right back up again. So again, on Facebook, make sure you follow us and you have the notification bell turned on. YouTube, you're going to see a little glitch. It's going to look laggy for a second, and then it's going to come right on back. So that again, that's when the court resumes in any moment now.
Hang out with.
Corey's phone, I kept calling her phone kept going to voicemail, so then I called Nick's phone. He put Corey on the phone. I said Darrell Brooks had just hit me.
I'm going to back up a little bit, if I may, to the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey went our separate way, and I went back to Frame Park. I went to Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Oh, he's in the other courtroom, it looks like. Okay, let me refresh. It's looking like the court is resumed. All right.
What I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, excuse me, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday,
Sorry, I was hearing double feed of it. Hold on, let me get it back. I was hearing a double feed of that, and I didn't like that. Let me get it back.
Presentation of evidence of
Oh, it's because he's in the other courtroom. That's why, y'all.
Control over the mode
Yes,
and
we're
order
back.
of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment because I think it's worth putting into the record once again the
It's from him being in the
language
courtroom.
of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility.
All
In
right,
the interest of
Facebook,
justice,
while
the
she's
judge
doing
may
this
limit-
quick, I'm gonna end it and then restart it while she's just reading that. All right, so come on right back. YouTube, you're gonna see a glitch really fast, so that way we can make sure that Facebook sees the entire stream for the afternoon. So give me literally 2 seconds. All right, come on right back, Facebook.
Over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I have done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself.
Echoing because he's in the other courtroom, y'all. That's what the echo's coming from. So I'm sorry.
At that
You're
time.
gonna have to deal with it.
At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof, for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted.
He's in the other courtroom.
I brought him, I should state it this way. He is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being we all would expect, have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous.
All of it.
I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder, he got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question, basically? Is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other act's evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906-16 and 906-08. Those are generally two of the statutes dealing with character evidence. That would be 906-08, 906-16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906-16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof
so no letter.
This letter that he claims was sent by Erica Patterson, and then the photos. The issue, as it relates to this witness, is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him, related to the other acts evidence, related to whether he has a relationship with the children or not, and frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not relevant. It is not probative. But certainly one could argue, based upon the questions, topics that the door could be opened to.
Yeah, I'm about to say it could be open. Possible.
It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I am not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong. That needs to include an offer of proof as to why he believes this letter is from Erica Patterson and why it's relevant to the issues in this case. Because he came in to the courtroom this afternoon and is not in here but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it. would remind him once again of SCR Chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them do unto you. Be respectful. Be kind. Give these proceedings the due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the record for that momentarily. An offer of proof if he wishes to do that related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? 7th. October 7th, I believe she was the third witness. We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
Well, all right. So while we're in a recess, I'm going to replay the ending of this morning's proceedings where they're talking about what just went down in case you missed it. So I'm just going to pull that back up again. Like the video if you haven't. This is live. We're in the afternoon session of the state of Wisconsin versus Darrell Brooks trial. Witness testimony continues. So again, this is I'm going to play the ending part that led up to why we're at where we're at while they're on break. I think I should start. It's ridiculous, but we'll start here. Okay, and then play it until they come back from break. And it sounds like he's going to be brought back into the courtroom again. All right, so he'll be brought back in there, get the proceedings going. We'll see how it goes. But here's the ending of the morning session in case you missed it. And it was wild.
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, "Oh, I wonder how you're doing," and oh, this and this and that. Oh,
I don't think
no, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that, but I don't believe she
But
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate to
Honor.
her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank, did you get a letter that's signed from her?
I got. What do you mean signed? No
How
one
do you
signs
know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna. When you
You're
say
not
to me,
answering my
when you
question,
say to me,
sir. What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like,
that.
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be.
I literally never sent a letter and not signed it.
Right,
so
so
keep
we
that
are
in mind. All right,
back
sounds like
on
they're back.
The record, I've been advised that Mr. Brooks does not want to come over to the main courtroom. Mr. Brooks, I'm advising you, you are invited back to this courtroom.
Audio's back,
It's my
no video
sincere
yet.
hope that you want to come back here. I see you're reading something, but we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. And I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay in that courtroom. I've been advised he can hear and see. Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no?
Supposed to be back on the record. Yeah, she's asking a question.
The audio is on. Would you like to come back to this courtroom, sir?
Unmuted. You're unmuted.
So I'm finally unmuted.
You've been unmuted for a while. Since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
Here we go with the bullshit again.
Record to reflect he's putting on the headphones.
What's going on?
Mr. Brooks, I'm inviting you
Yeah.
back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't say nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I didn't hold you in contempt.
Then why am I even over here?
So that I could make a ruling and make a record without an interruption pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if
keep
you
being
don't
held in
answer yes or
contempt.
no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I
He
will
literally is-
close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
So another little
And for the
short,
record, I do not consent to being called that name.
but he's been called Darrell Brooks all day long. All right, so we're gonna go back to where we left off because now he has to come back into the courtroom. It's gonna take him a short. I'm gonna keep it on the screen.
I don't know why she think I can hear everything she's saying perfectly clear without the headphones. Oh, that's a trick to hold everything up too, right?
Hold on, hot mic. His microphone's still on.
Yeah, I might as well stay over here.
All right, now they shut it off. Okay, just wanted to make sure we weren't missing anything with the hot mic. Oops. So again, this is just going to be like a couple minutes while they bring him back into the courtroom. Jury's still on the recess. They're not in the courtroom yet. So he's being brought back. Here's the ending of the morning that led up to him being removed from the courtroom.
To be put in a legal
The
term
bottom
or
line is
something?
I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here.
Okay, so I'm going to skip forward to the part where the state comes in and just kill shots. All right, here we
Some
go.
other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe it's.
I didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
Here we
My
go.
position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
So again, they heard him on the phone talking to his mother to send him those photos. So there is no letter.
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness. if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has.
Oof.
He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end
finish.
of the day,
I'm not done. Got him. So he's a predator too.
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me
disrespectful,
she was when
interrupting.
we met. We can ask that question
he is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be
All right, so they removed him from the courtroom, which is where we're at now, and now he's coming back in. And when they came back, oh, also quick, I was going to play this after the lunch break too, but someone sent this to our Discord. Where is it now? Is it in the... There it is. So he had said this years ago in relation to you know, the wife of it, or excuse me, the mother of his child was underage when he impregnated her, and so this is what he had to say about that.
10 years ago, 2006.
So this was in 2016. He recorded this.
I caught a case with my oldest daughter's mama. Yes, my baby mama. She's from Oakland. I was busting moves in Nevada. I meet the say she want to get down, so I'm pimping on the I'll take her to Nevada. You know what I'm saying? I get cracked. You know what I'm saying? I didn't know the was 16 at the time. She gave a statement to the police and told them, yeah, she was and that I was in and that she was 16 and that I didn't know that. Okay?
All right, so that's what he said that in 2016, with full intention to do what he did. All right, full intentions. And then, okay, well, we're still waiting. I'm going to replay what the judge had said when she came back from the lunch break.
From my perspective, disagreement with...
Again, it's going to be double audio for a bit of this just because he's in the other courtroom during this.
Wanted to narrow things down a bit, as is my not only right, but frankly my obligation under 906.11 to make sure that there is an effective presentation of evidence and exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses.
All right, so it looks like they're back. Judge just moved, so
Sir,
we're going
if you
back
have
to the
one.
live feed now.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof
We
to
go
provide,
past all
sir?
that. We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Right.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the
I just said no. I just said that.
Because he
All right,
lied.
thank you. Then, based upon there being no offer of proof, then my decision stands.
Liar. You didn't have no
As to
letter.
the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
So mask is back on now and jacket's
What
off.
topics generally were you going to question her about?
Mask on, jacket off. He's all flustered after what that DA did. DA fucked him up. Got him.
I guess I'll have to look in here because so much that happened since over the past hour and a half or so.
Right. Because you got called out. Narcissists
I can
hate
tell you
being
one
called
thing.
out.
I don't intend to I don't intend to have too many more questions, I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I don't remember her, what do you mean by related to her direct, is that from the last time she testified?
From the first date that she testified and from today? What
remember,
new topics will
I don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to prevent relevant and probative evidence, but under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already covered.
What, pursuant to the police report or something? Is that what you're asking?
No,
I don't understand.
I'm asking you, I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you say it related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only...
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here.
Do
Possibly
you see a written statement with her signature
I
on
will
it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson?
No, Your Honor.
It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report.
Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about so I know with specificity?
Oh, I'm looking at it now. How many officers did reports? Because it seemed like it's more than just two. At least from this paperwork, is more than two.
Like the video if you haven't. Also, make sure you're following. Subscribe to the YouTube channel.
Mr. Brooks is referring to. I can maybe help him try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. Right, statute.
So I've got pages 2 and 3 out of 6 from Detective Barrett's report under Waukesha Police Department incident number 21-047533. This is one of the two reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the questions.
Under my authority, under 906.11, then And given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand, what do you mean by closed?
Like you're done.
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
How do I? First of all, the report isn't even in order, so I would have to
That's a
essentially
personal
read
problem.
at least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out. The jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I
then,
have
if
to do
can't-
that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's.
So I'm being held in contempt again?
No, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your right
So I
to
might
be
as well just
present.
I might as well have just
No
stayed
such
over there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
going to get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're going to
Just
continue,
take me over there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal?
Oh my goodness.
Why am I being
Mr.
held in
Brooks?
contempt?
I'm going to keep you in here because
that's the whole reason
you're
I
going to need
didn't
to
want to
call
come.
the next witness, and I'm going to need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
Well, I'm
She's
finding
not.
a reason, and it's not
Oh,
contempt,
yeah.
but I'd find a reason to remove you based upon your disruptive
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I
Obviously
want you
you
in
do.
this courtroom.
Obviously you do. You brought it up before we can even get to.
All right. Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though
did
it will be
I
short,
actually forfeit that right?
you have forfeited your right to be present. That
And
is
how
the-
did I forfeit that right, Your Honor?
All right. We're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding you in contempt.
Then what did I do?
All right, I'm going to step off. You've interrupted repeatedly. I'm going to step off.
God dang. Gosh darn. He just he's no it's coming to an end. It's all coming to an end for him, so he's just imploding now at this point. I don't even know where to go. I'm just gonna leave it here, y'all. We're just gonna stay here for a bit. I can't replaying it over and over again is driving me nuts. So we're gonna wait for the couple minutes that it's gonna take for them to come back, and we're not going anywhere. Like the video if you haven't. Make sure you're following us on Facebook. You're subscribed to the YouTube channel. Notifications turned on for all coverage. Trial will resume again on Monday. We'll have Ukraine war coverage still tonight and tomorrow. So tune in at 7 o'clock Central, 8 p.m. Eastern. Shout out to all the orc hunters that tune in to the Ukraine war coverage at nighttime. Oh yeah, it's classic narcissism and gaslighting and all types of toxic traits that have never been checked. He'll get wiped down in prison. He's spiraling, even worse. Comment where you're tuning in from, what city, what state, where in the world y'all are watching from. Again, this is live coverage on Mercado Media, Facebook, and YouTube. We are still live. We're going back and forth, and this is going to happen again because he's likely going to be brought back in again for the next witness, because he's going to have to call the next witness. So he's only out of the courtroom for the judge to dismiss Erica Patterson and ask if the state has any cross for the witness, which likely they're not. And then she will do this again and ask him if he's ready to be brought back into the courtroom. So we're going to at least do this again one more time. El Paso, Germany, Denmark, Copenhagen. And I've already brought up what she keeps referencing in another stream. Let me bring that up quick. The Illinois versus Allen. It's a Supreme Court ruling. Has to do with unruly defendants that are representing themselves. So Illinois versus Allen. Let me pull this up here. Again, when they return, we're still here. I'm not going anywhere. I can't replay any more old footage right now. It's driving me nuts. So here's the U.S. Supreme Court decision, Illinois versus Allen. The respondent, who was on trial for robbery, was removed from the courtroom for repeated disruptive behavior and the use of vile and abusive language directed at the trial judge. Notwithstanding the judge's prior warning that removal would follow another outburst. Appointed counsel represented respondent during the period respondent was not allowed in the courtroom, principally the representation of the state's case. Having given some assurances of good conduct, respondent was allowed to return to the courtroom while appointed counsel presented his defense. Respondent was convicted. Following the state Supreme Court's affirmance, respondent filed a petition of a writ for habeas corpus in federal court, contending that he had been deprived of his right under the 6th and 14th Amendments to confront the witnesses against him. The district court declined to issue the writ. Okay, they're back. So basically, the judge is trying to prevent all of that because it's happened. And she's citing a Supreme Court case that's already had happened for that. So under Illinois versus Allen, held 1, a defendant can lose his right to be present at trial if, following the judge's warning that he will be removed if his disruptive behavior continues, he nevertheless insists on conducting himself in such a disruptive manner that this trial cannot proceed. If he remains in the courtroom, he can reclaim the right to be present as soon as he is willing to comport himself with decorum and respect. A trial judge confronted by defendant's disruptive conduct can exercise discretion to meet the circumstances of the case, and though no single formula is best for all situations, there are at least 3 constitutionally permissible approaches for the court's handling of an obstreperous defendant. Goodness, these are big words. Bind and gag him as a last resort, thereby keeping him present, which I think we've seen. There was a viral video of a defendant who got bound and gagged in the courtroom. So this is actually from per a Supreme Court ruling. So that is an option. Or 2, cite him for criminal or civil contempt. 3, remove him from the courtroom while the trial continues until he promises to conduct himself properly. And also, I just think Judge Darrow is just trying to also prevent this trial from going any longer than it needs to and get him into prison for life without possibility. Trying to keep him on course for prison time. On the facts of this case, so number 3 is, on the facts of this case, the trial judge did not abuse his discretion, respondent, though his disruptive behavior having lost right to confrontation under the 6th and 14th Amendments. Hello from northern Wisconsin, how you doing? No, if they were going to go that route, she would have done it already. If they were going to go the binding and gagging route, that would have happened. Yeah, it would have happened already. Judge already said this has been the most trying criminal proceeding she's ever done. Most stressful, trying criminal proceedings. It should be back any minute. We are on day 12 of witness testimony. Louisville, Kentucky tuned in. Again, they should be returning any moment. We heard the chains. So he was likely brought into the second courtroom so that way this thing can get going. No, she's kicked him out already. This is the second time today he's been kicked out. So it's not the first time today. So somebody had asked who has testified so far today. It's been a witness at the parade. Detective Guth and Erica Patterson have been the witnesses for today. All Darrell Brooks's witnesses. Still has more on the list. We'll see if they get to him. Here we go.
Please have the jury brought out and make sure all the monitors are on. You are unmuted, sir. The jury is on its way in. Well, will be shortly.
Why didn't we address subject matter jurisdiction when I was over here?
I'm going to mute you if you do that, sir.
I'm not gonna do it when the jury. That's why I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record? Will I at least be told why I'm held in contempt when I didn't do nothing? Civil or criminal?
That's a misstatement of what I did, sir.
So why am I
I
over
will
here?
advise when the jury's coming in, and if you can't be quiet, you're going to be muted, sir.
You're gonna mute me anyway.
Not if you're quiet.
So I gotta be quiet like a little kid?
It's not what I said, sir.
You are a little kid.
You have to be
That's what
respectful.
you said.
You have to be respectful of the proceedings.
But nobody has to be respectful to me though.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen it through the TV screen and made me feel uncomfortable?
Jury's coming in. Please rise for the jury.
So that's not gonna be addressed. Okay?
Mr. Brooks, I'm muting you.
Bye.
Oh, okay.
Let's go.
That's the federal district.
Hell yeah.
It was late.
So much better when
Okay.
she can just mute him. Judge is just over it.
Can I have the preliminary instructions for a second? Oh, sure. We should just keep them. They're nearby. Thank you, everyone. Please be seated.
Notice how he didn't need the damn headset now to hear.
Just for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness?
I don't have any questions for Ms. Patterson.
All right. Thank you, ma'am. You may step down. Thank you for being here.
She's got to ask him again, are you ready to return to the courtroom to call your next witness? Help.
All right. The defense may call its next witness, please. Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
So how long am I supposed to stay in here now?
I'm going to excuse the jury. We'll hopefully have you back shortly.
Here I go. Told you. I'm gonna play this game.
All rise for the jury, please.
Literally, yo. Literally, I am going nuts. I can't believe this is real life. What a stressful Friday. Help! Imagine being the jury for this, just constantly going in and out of the courtroom like some cattle. Jury getting their steps in today.
All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness?
Is that going to be held in contempt?
You're not muted. You're unmuted.
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a
unruly
defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer
Mr.
for
Brooks?
me. You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will. He's interrupting me once again.
Okay, you talking. Courtroom. You the one talking right now, so don't do that.
I'm going to mute him because he's not being respectful and he's just spouting off.
Let's go.
So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because, number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your
Don't-
next witness?
Don't try to seem like you're trying to honor my rights now because you haven't
Okay,
been doing
he
it before.
is, again, not
Don't-
answering the
don't-
question
Don't try to
directly.
put on no, don't.
I'm going to mute him again. As I've
like this
noted
better.
before, this is a clear method now that Mr. Brooks is employing, that when I've done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he is continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I've confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses.
Oh, she's laying the hammer down
So
now.
I'm going to unmute you. Actually, I need to bring the jury back out.
Sounds like
but
court's gonna end
before
early
I
today.
do that, I will unmute you first and ask you which witness you intend to call, so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Okay.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made
gotta
a record
answer
of that,
everything.
sir.
Help.
I have to answer everything
help.
though.
I'll
Everything
be back
you ask
out.
me, you expect me to answer. But then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because frankly you keep interrupting me and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not
Brooks.
a delay and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make,
Let's
sir,
go.
is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now you're not doing anything legally relevant, you're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off, so I will... Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted, who is your next witness?
She trying to say something to me? Yeah.
Who else is she talking to?
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones? You
Yeah,
choose
because
to
I'm
read?
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again?
Who else would she be talking to?
This-
We gotta keep doing this little childish stuff, dude. I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses.
where that's law.
Because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay,
gladly bring you back into this courtroom so you can present your additional witnesses.
You're
But
right.
you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day.
Oh my God, he is
It's
so.
not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally trying to be disruptive. Because that's not the case. And I feel very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. That's not up for debate. You control what's going on in there. That's not a dispute. But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay. So now, where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can raise that issue on appeal. You can
This is
raise
why I
that
say that.
issue on appeal if you are
This is why I say
convicted.
that. This is why I say that though. Because I can't even see. The only thing I can see right now when I'm looking at the TV is you Is you
and the prosecution table. I can't see anything else.
I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom.
What's going on in the courtroom.
Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So, I'm not going to have a debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you going to kick me out?
Sir, it's a yes or no question. Would you like to come back into this?
My answer was based
Somebody
on
end
the
this
reason
time
why
loop, please.
I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth. It makes essentially it wastes time, really.
I'm well aware of that, sir. That it delays the proceedings.
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
Sir,
Yes.
I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements of courtesy and decorum so that you don't run the risk of forfeiting your right to be present. But that falls on you and you alone, sir.
There is no conduct. I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine. I can't argue
And
with
you have
about
demonstrated
it.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor,
represent
that's not fair.
yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you do
not
so
fair.
at your peril.
That's not fair to state, Your Honor.
At your peril, boy.
So I'm going to do the following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over, or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue, so we'll go off the record, and he will come back over here. Thank you. We are in recess until that happens.
Come on, bruh.
I mean, just to say something and then get kicked out. Man, I don't know what to tell her then. So
She's taking a break right now, wants us to take you back, have you go back.
I don't, no, because I'm gonna end up having to come back over here and
Don't y'all get tired of hauling all this stuff over here, over there, over here, over there, over there?
Absolutely.
And I know, as soon as I say something, she's gonna say, take them out. We're gonna stop everything. Take them out. And it's just like, well, damn, I could have stayed over there.
I have nothing else to say. He's just a manipulating narcissist.
It's like, what the hell?
I'm just here for security, so if you want to go over there, I'll let them know you're coming back. If you don't, we'll let them know you don't want to go back over there.
I'm gonna go over there and get sent right back over here. And then when I get over here, it's gonna be the same thing. Oh well, if you tell them you can come back over here, then I go back over there, then I get kicked out again. Then it's the same thing again. Oh well, if you want to tell, it's just like, dude, pick, man. Like obviously, I don't have no say. That's clear. Because when I'm getting kicked out, the first thing I say is what? So why are you holding me in contempt? So that's obviously saying, why am I being kicked out? So if I'm saying, why am I being kicked out, then obviously I don't want to be kicked out. But then I'm kicked out anyway, and then I get over here, and it's just like, okay, I don't want to be over here, but why I got to go back over there?
Oh, now they cut the mic. Dang. Well, that was a hot mic in the other courtroom. So he's going to be brought back again, or I don't know if they bring him back or just through the TV, through the computer. And then judge is going to apparently ask him 3 times if he has another witness in front of the jury. And if he doesn't, he's gonna forfeit his right to call any more witnesses, which please, because we're almost there. All right. Likely will get done next week. All right. Likely will get done next week. Like the video if you haven't. Spam those reactions on Facebook. Don't go anywhere. I'm not going anywhere. We're going to be live with this. I'm not going to play old footage right now. They've taken like 3 breaks so far, and I can't handle any more of the manipulative gaslighting out of this guy. We deal with it from another country at 7 o'clock, so I can only handle so many hours of manipulative gaslighting in one day before I just melt. So join us at 7 o'clock Central for coverage of the war in Ukraine. You want to see some more? 7 o'clock Central, 8 o'clock Eastern. So again, we're just waiting for them to return, come back. Gonna ask him 3 times if he's ready for another witness, and if not, it is what it is. His peril. Darrell Brooks is 40 years old. He's a 40-year-old man, child. So if you're just joining us, we're still covering this live. We're just waiting for the court to resume. Brooks was removed from the courtroom, and now he has to call another witness before the jury. And if he fails to do so after being asked 3 times, the judge is going to forfeit his right to call any more witnesses. So we're just waiting for that to resume here this afternoon. You are watching this live on Mercado Media Facebook page and YouTube channel. Oh, T-Gus, thank you so much for joining. Welcome to the channel. Thank you.
The record should reflect that Mr. Brooks is present in the courtroom in person and in custody wearing a suit and tie. Actually, his suit coat is off, but he's still wearing a mask. And the jury will be brought out, and you'll be asked to call your next witness.
And we're back.
You ain't called that name.
So noted.
He's back in the courtroom.
We still need to address subject matter jurisdiction.
He literally has...
Before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
All right.
He has a stress ball. Look at it. Hey, Sue has a stress ball. I don't blame her. There's a hopeless person. No hope.
Thank you, everyone. Please be seated.
Alright, we're back. Like the video, share the stream, all that. Hopefully we last longer than 10 minutes before another break.
The defense may call its next witness.
Who's here?
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
Let's go with Deanna Aldridge.
Deanna Aldridge? All right, very well.
No, the only hope for him is to get counseling in prison so he doesn't get killed in there, honestly. He's gonna be in there for life. He's gonna have to figure out how to survive, and this isn't gonna cut it. So hopefully, or whatever, but that's pretty much his only hope. Counseling while he's in prison to prevent others from dealing with it.
I'm sorry, Your Honor, I think she was in the other building, so.
That's all right. Thank you for letting us know. Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Come up and have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Okay. Deanna Aldrich, Deanna. Last name is Aldrich.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldrich. Direct your attention. Well, first of all, let me back up a little bit. What do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV?
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
description-wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down?
down, yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were going to walk up to the vehicle, but they did not because I yelled to them and said, don't touch it.
So that kind of would be fair to say that kind of startled them and stopped them in their tracks?
Yeah.
Do you recall how many people there were?
Maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
If you recall, did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, which street did you say?
Arlington.
Arlington. I apologize.
Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Do you recall the name of the officer that interviewed you?
No.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor. Thank you.
Thank you, ma'am. You may step down. You are excused. Defense may call its next witness.
Just 1 second, Your Honor. The defense calls Christopher Bertram.
All right, thank you. I presume the state heard that and was assisting.
Yes.
Thank you.
Your Honor, my assistant.
I didn't want to assume, so thank you for
Yes.
verifying that. Looks like this one's a lot closer than before, so that's good. All right, good afternoon, Mr. Bertram. If you would please make your way to the witness stand, which is off to my right. It is up one riser. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Have a seat, please. First thing I will ask you to do is to state your first and last names for the record.
My first name is Christopher, and my last name is Bertram.
Could you spell those, please?
CHRISTOPHER BERTRAM.
Thank you. As long as you sit close to the Cable, you will not have to lean in. Go ahead, sir, your witness.
Oh, I'm sorry.
Go ahead, your witness.
First of all, good afternoon. What do you currently do for a living?
I do electrical work.
Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our mechanic friend.
Were you aware of a parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
And at the time you observed this smashed up car, as you say, did you see anyone driving it?
Yes.
And were you able to make a description? Sorry, description of who was driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
You made reference to giving a statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview, over the phone, or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording it?
I don't recall.
Did you observe the vehicle stop at any point in time?
No.
So it was pretty much you just saw it just kind of just rolling past?
Yes.
Did you notice if the vehicle had any tents?
Any what?
Tents, like tinted windows?
No.
Do you recall in your interview with law enforcement, well, let me back up a little bit. Was your interview with law enforcement the same evening that you saw this vehicle or sometime after?
The same evening.
Do you recall stating during the interview that evening that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
No.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
Do you recall in your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
And where did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
I do not remember.
Do you recall during your interview with law enforcement that evening stating that you thought the operator was wearing a black sweater or jacket as it drove past you?
If that is what is written.
Do you recall saying that?
No.
And do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
And was anyone present with you during your interview with law enforcement that evening?
Yes.
And who was that?
My mother.
And do you recall what agency your interview was conducted by?
Yes.
And would you state for the jury in the record?
The FBI.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do you recall I think that's a little bit unfair to say. If you had to estimate where do you think those gunshots were coming from, like vicinity-wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
Do you recall seeing the vehicle that you observed crash into anything?
No.
Do you recall stating in your interview with law enforcement that evening that the vehicle appeared to slow down while traveling down Prospect Court?
Yes.
At some time after observing this vehicle, did you call 911?
Yes.
Do you recall around what time you called 911?
No.
Do you recall shortly after seeing this vehicle texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
Possibly.
Did you see anyone else in the vehicle?
No.
But you do recall seeing the operator wearing a black sweater.
I don't remember.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds?
His answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross?
No.
Thank you, sir. You may step down, and you are excused. All right, go ahead and call your next witness.
And when we get to the next break, I have something to discuss outside of the presence of the jury. If that pleases the court.
Do you want to do that now or after your next witness?
We can.
All right, I'll address a legal issue, and we'll bring the jury back in when we're ready. I'll rise for the jury, please. Everyone can have a seat, and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then
about
that's...
that.
All right, then I'm going to bring the jury back out and you're going to call your next witness.
Playing games.
So I'm not hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden the
with
state
these
don't
witnesses.
got. All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on
point.
the record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in fact.
But I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe.
So I'm gonna start asking every witness up
Survey
here that they
says-
seem just to
New poll.
mysteriously now not
Let's see
have
what
any
the-
cross
let's see what the
board.
chat
Have
says.
they been coached to answer the way they answer?
Well,
Because
you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for something.
by you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on, man.
avoid the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
Oh God, help me, please.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is to benefit you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like, I don't know. Y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can
believe
you
he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, an OWI 3rd from 1997, an OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's
What the
very
fuck?
disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
What the fuck? Yo. What in the fuck, dude? Don't go anywhere. My goodness. What was that? So let's rewind that little bit there. As soon as she brought up his past again.
Say anything about that.
So we're just going to replay that little bit. And holy shit. So we're going to go from here. Wow. Wow.
I see the whole strategy here by the prosecution.
Yo.
I see right through it. Don't have any cross-examination. Mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out and you're going to call your next witness.
We need a reel of that, Mod.
I'm not hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden the
with
state
these
don't
witnesses.
got. All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this
You
is
better be shackled like when they return. Like what the fuck was that?
argument.
I'm still shook from that.
Man,
This is argument on your part, sir. It is pure commentary
I just
at
want
this
that on
point.
the record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Yeah,
fact.
I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
You got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes
No,
out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can
believe
you
he
split?
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003.
Fuck.
Criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
And that's where we're at right now. I'll keep it live here. I don't know what's going to happen. I do not know what is going to happen. I'll keep the jury in recess up because they are. You could hear him breathing too heavy after he pounded the table. What a psychopath. Put this dude away forever. That's like every time they go into his past, he melts down. Can't handle it. And that was the worst of it now. Imagine what Erica Patterson's been through. So, all right, that part one more time. Okay. All right, one more time, and then we're going to wait because I don't know how long this is going to be. So, all right, from here.
The defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one.
Mr.
I got
Brooks.
one ear that work, and I heard that.
This
Come on,
is
man.
to benefit you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for that.
Lescott.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can
believe
you
he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
All right, so that's where we're at now. So let's go back to the end questioning of this witness that led up to that point. All right, so we'll start from here. The live video's on the right side of the screen, so when they do resume, I'll just click live, and we'll start from when they return.
When initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds?
His answer may stand.
What was the answer?
He said, I don't recall. Or I don't remember.
No further questions at this time.
Thank you. Any cross? No. Thank you, sir. You may step down and you are excused. All right, go ahead, call your next witness.
And when we get to the next break, I have something to discuss outside of the presence of the jury. If that pleases the court.
Do you want to do that now or after your next witness?
We can.
All right, I'll address a legal issue and we'll bring the jury back in when we're ready. I'll rise for the jury, please.
This guy's got to go away.
Everyone can have a seat, and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to
No, the jury did not see that. No.
To law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then
about
that's
that.
all right. Then I'm going to bring the jury back out. And you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this
and
is
not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on
point.
the record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in fact.
But I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe.
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
Well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes
Nah,
out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be
the-
said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell?
I
can you
believe he
explain?
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
And that's where we're at now. All right, so that's the full context of where we are. Stare down, pounded the table, and the judge stare down. And we've been at break. All right, we're back. No, all right. Like the video if you haven't. Follow the page on YouTube. Or excuse me, follow the page on Facebook. Subscribe to YouTube. State of Wisconsin versus Darrell Brooks. Post stare down of the judge. We are back. Join our Discord server, join our Telegram channel, links in the description. Both excellent resources to stay up to date with all live streams from Mercado Media and news updates. Watching from southern Spain, thank you. Also comment where you're watching from. Let me know, check in.
They were before. I'd like to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness. I trust that you're ready to do that, sir. All right, then.
And we need to complete the task of the
Oh, we do.
priors for Mr.
I knew I would left something in my office, but I reviewed it, so go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously that would not have been a crime. But everything from OWI second on down we believe would be appropriate. There's also one that's noted, 06CM2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Liscano.
That was going to be kind of my next topic once, thank you, I look at this again. All right, Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
What? I don't know what you're asking.
Mr. Brooks, you may recall at some point I believe we had a discussion about prior convictions. I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't
No,
think...
there was one state's witness that had one prior that we discussed and
That's
the court
right,
ruled.
we did. I recall now. So at that point, I directed your attention to 90609, and then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039, 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in, 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that file.
So why is it on the sheet?
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
What is dismissed and read in? Does that mean there is no charge?
No, it means it was when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why, my understanding why it was listed.
So the two. So where it says dismissed and read in, that would be the restraining order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8. Should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI?
An OWI first would not be a crime, it would be a forfeiture.
I still would say 8, just based on the fact that there's continued OWIs. All the way up to a 5th.
Remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Less than what, 8?
Well, it'll be less than 7. He has 7 convictions as I count them.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7. Should be 7.
All right. Do you want to make any argument about whether any should be excluded under the statute based upon the factors I just read to you?
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole...
well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
I don't want to speculate on the next man's life. But if it's 7 on here... well, I guess it brings it to 7. And whether OWI first is not a crime, it still counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first. Looks like 7 to me.
All right, then. Anything further from the state on this?
No, Judge, thank you.
Given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Liscano before he testifies, Your Honor, I believe.
I agree. State willing to relay that information?
I'd rather not. Given the accusations levied by Mr. Brooks, I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr. Liscano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
For sure, Mr. Hayes and Mr. Liscano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
All right, so Hayes and Liscano are still here?
Yes.
All right. Those are the 2 who are here, sir. Tell you what, either way, let's just bring Mr. Lascano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please. Can I have a first name for this witness, please?
It's
Abel?
Abel,
Thank you.
but I believe it's pronounced a different way. It's A-B-E-L. What did she say? Abel.
Abel, thank you.
Abel.
Subject matter jurisdiction, Your Honor.
Court declines to address that.
Still has yet to be verified and proven for the record.
Your objection's noted for the record. Do you want Mr. Lascano on the stand, or are you going to call Mr. Hayes first? Just so I know what to do when he comes in.
I don't currently have, I can't find paperwork from Mr. Hayes. Can a police report or something be provided in case I want to call Mr. Hayes first?
More personal problems.
Yes, we will accommodate that request. It'll just take me a minute, Your Honor, to find it. I'll have to have it printed and brought over, or Mr. Witchow can run. Thank you, Mr.
I will give you
Witchow.
permission to email it to Teresa, and she can print it in the courtroom. That will assist.
It's part of a 700-page PDF, so I can't just email one page.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
That's all right. You can do it the way that you need to. All right. Mr. Lascano, I'm just going to have you, for a moment, take a seat. You're not going to testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to have you come up to the witness stand. Everyone can have a seat. I want to advise you that I'm aware you have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then. Thank you. All right, then let's have the jury brought out, please.
All rise.
Like the video if you haven't. Make sure you're following on Facebook. Subscribe to the YouTube channel. You're watching this live on Mercado Media.
Thank you, everyone. Please be seated.
Thank you for supporting
The defense may
independent
call its
media.
next witness.
Veteran-owned media. Thank you so much.
Defense calls, is it Jason Hayes? Jason?
All right. We'll have the witness brought in. Is it Haynes or Hayes? Does anyone know?
No N to the best of my knowledge.
Hayes?
No end, no.
All right. Good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir. Your witness.
Just 1 second. I accept for value and return for value this document for the record. Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
Been doing that for a long time?
21 years.
Yeah, it's a long time. The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
What were you doing that evening?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
Were you scheduled to do any marching in the parade itself,
No.
or just spectating?
Yes.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah.
I just wanted to make sure there was.
Yeah, he answered. Anything unusual catch your eye that day that you recall?
Yes.
And what did you see?
Besides the parade?
Yeah, I'm sorry. That was unusual that caught your eye that evening.
Well, where we were, yes, a red truck came through where we were. It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that
We
time?
were all the way at the beginning of the parade.
Okay.
Like, it was Main and the corner of Main and White Rock.
Okay. And you said you observed this vehicle honked and swerved?
Yes.
What did it swerve from?
I'm sorry?
What did it swerve from?
Where?
Or was it, I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or?
One honk.
Do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
So well, before we get to that,
Did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main, east, the same route the parade went.
Did you get a description of who was driving the vehicle you saw that day?
I did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did, by a detective.
And do you recall if that was the same evening or?
It was not the same evening.
So
it was a couple days after.
Yeah. Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes.
So in your opinion, it wasn't trying to strike the kids?
Correct, yes.
And after it continued, I think you said east?
Yep.
Would that be correct? East?
Yep.
Did you see the vehicle strike anyone?
I did not, no.
Do you recall what side of the street the vehicle was traveling on at that time?
It was on the right side.
On the right side.
So we were on the north side of the road.
Okay. So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never saw it go to the other side of the road or?
No.
No further questions at this time.
Thank you. Any cross?
Yes, just briefly. Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that?
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled. The state may continue asking the question.
I guess I was asking was that referring to the interview officer?
Your objection is noted. It's overruled. The state may ask the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face. You couldn't
No.
identify anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirects, sir?
Briefly, very briefly. You made a reference to the driver of the vehicle having a dark complexion. What would you consider a dark complexion?
A dark complexion. I don't know.
It is kind of hard. Did you notice any clothing?
I did not. No.
Did you notice any hair?
No.
No further questions?
All right, thank you. You may step down. And you are excused. The defense may call its next witness, please.
Quick question before I do: who's supposed to be arriving at 3:30? Just so I know.
I'm not sure.
Babiettes and Urel will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
I knew it was here now. Just trying to get clarity.
Are you going to call Mr. Liscano?
It would appear so. He's the one that's here.
All right, then he may. The defense is calling Abel Liscano, correct?
The defense is calling Abel Liscano.
All right, very well. We'll have him brought in. Thank you. Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. And my clerk, Teresa, who will be across from you or is across from you, will swear you in. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Liscano, ABELLAZCANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Liscano. What do you do for a living currently?
I'm a hairdresser.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Do you recall the night of November 21st, 2021 pretty well? I know it's been a minute, but...
Best as I can, yeah.
What were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or?
No, I was watching it.
Who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Okay. Is that part of Main Street close to like a side street? If you recall?
It's not too far from Maple.
Do you recall the side streets being barricaded during the parade?
Yeah, I don't remember.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection. First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Is that all you recall about your description?
That's all I remember.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or what building on Maple Street.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop, no. It kept going through the parade.
And speaking with, is it Detective Moss? Well, speaking with law enforcement that evening, do you recall advising law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this. I'm referring to page 4 exactly.
Is it a statement this witness personally wrote?
I believe it's with, I don't think he wrote it himself.
So it's a summary written by another person?
By, I don't know if it's Officer Moss or Detective Moss. I'm not sure what his rank is.
Continue with your questions. I'm going to deny the request that you show the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says one was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other 2 were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car. Trying to get them to safety. So I was keeping an eye out and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No. When I found it, it was parked already.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to where the vehicle was ultimately found?
Yeah.
Do you recall yelling at subjects standing outside of a building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
Do you recall stating that, well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
Yes, I did.
And do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening.
Yeah.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. And there was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, in reference to seeing the vehicle in the parade as it passed you. do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
Any reason why the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Do you recall in your interview with Detective Coates that evening stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so it's clarification. The 3 individuals who were standing in a line shoulder to shoulder as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
I saw at least 2 of them. And it looked like they were standing in front of it.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
I don't remember.
Any reason why multiple, well, I'm not going to say multiple, 2. Any reason why the 2 detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
And during the parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
Thank you. Any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes? Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overrule. It's crossed.
No,
Speculative. Objection.
Overrule. The witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
Overrule.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overrule.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay.
And while the witness was giving the answer, not the last answer, but the one prior to that, he had his right hand in the air, directioning his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Thank you. So, Mr. Liscano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Go ahead.
Objection to the relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may proceed.
All right. This total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's shown in this picture?
Yeah, I believe that's Central Middle School.
Where?
Right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection
Okay.
speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
Overruled. You may answer.
Yes.
That looks right, correct, sir?
Objection leading.
Overruled.
All right, we're going to clear the screen, please, and we're going to play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor? Is that a tacit agreement?
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 or more people. I don't know if they were, I'm sure they were white, but
okay.
I was trying to not make it obvious at the time. I believe that they were with the vehicle, so I didn't want them to see that I saw them, so I just did what I thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
No, I do not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection. There was never any crash mentioned.
I'll sustain. It calls for speculation.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection mischaracterization of that testimony.
Overruled.
Yes, there was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection speculative.
Overruled, the witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay. You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection speculative.
Overruled.
You said
And
that...
it mischaracterizes the testimony because that was not testified to before on direct.
Oh, your objections are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it.
you?
No.
Okay, just wondered. Mr. Liscano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case or your testimony?
Objection hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
And how did the driver look that day you saw him?
He had a scruffy beard, and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance? Tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street. I wasn't paying attention to the color of clothes you were wearing. I knew it was a black male and had a scruffy beard. It's the first thing I told my wife, is he was a black guy driving.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
Well, it had to be a couple seconds.
And in a couple seconds' time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard. You can tell if you were white or if you were black and if you had a beard or not. That's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
So that leads back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's
fair,
the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification,
You already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, 2 different detectives, the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
And during both interviews with detectives that evening, the evening of November 21st, 2021, you also stated to both detectives that you observed 3 or 4 black, or African American is the word used, 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
I expect.
No further questions.
Thank you, sir. You may step down. Do we have additional witnesses here?
Yes, Your Honor, they're ready.
All right, would that be how many people?
There's 2 left.
Okay, so the 2 left on your list. Your next witness, sir.
Like the video if you haven't. Make sure you're subscribed to the YouTube channel and you're following on Facebook.
I'm guessing that's...
You're watching this trial live on Mercado Media, Facebook and YouTube channel.
Just give me 1 quick second, Your Honor. 1 quick second.
Go ahead.
Sorry about that, Your Honor. I'm just making sure I have the correct paperwork.
My jurors need to stand. Go ahead.
Also, check into the stream. Let me know where you're watching from. Shout out to the Orc Hunters. Tune in tonight at 7 p.m. Central, 8 p.m. Eastern for an update on the war in Ukraine, right back here on Mercado Media. You're watching the state of Wisconsin versus Darrell Brooks. Oh, their feed paused. Oh, their court feed paused. We gotta fix that. It's not good. On TMJ4.
Okay, great. If she could print it, that'd be great.
So much paperwork. He's just stalling. His new rap name should be Lil Grounds and Lil Stallings.
Okay, I'm ready, Your Honor.
Go ahead. Call your next witness.
Kathleen Urel?
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 That's how I think it is. We'll find out. All right, ma'am, if you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left, will swear you in. Go ahead and come all the way up. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Kathleen, K-A-T-H-L-E-E-N. Last name Urel, Y-O-U-R-E-L-L.
Thank you so much. Your witness, go ahead.
Good afternoon, Miss Urel. Is it Urel?
Urel.
Urel. What do you do for a living?
I'm in workforce management for a call center.
November 21st, 2021. Directing your attention there. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial meaning maybe a few minutes?
Until my group of children went by.
Okay. Do you recall where you were positioned during watching your group participate in the parade?
Yes, on north and east, right on the corner there.
North and east.
If you're going parade route, it would be on the right-hand side.
Okay. Just so we have clarification, can we pull up the exhibit, I believe it's 15?
We can.
Thank you.
Go ahead. And thank you.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet. Just I want to make sure the witness gets a chance to view it first. Can you see that on your screen yet?
I do.
And using the touch screen, it's a touch screen. Can you point out where
It's not published, so do you want it published?
I'm sorry. Yeah, publish.
Sorry, I didn't mean to interrupt, but I just wanted to point
So
that out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we gotta wait on the jury, right?
Thank you.
For the jury, can you, using the touch screen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching it.
right on the corner, sorry. Oh, well, if you want
Can
to
you
erase
clear-
it
can you
again,
clear
I'll
the-
do it again.
the arrow?
We'll clear it, you can do it again.
Yeah.
If you don't want, do you want the arrow?
Well, it was to the...
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was gonna
Can you
say
clear
that.
Well, I mean, it was right there, but...
I was gonna say a circle or a little dot if.
Well, I thought I would do the dot, but...
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
There you go.
And you said that would be approximately East Main and Northeast?
Correct.
And do you recall if those, well, there's side streets right there that you can see, is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from there?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? Would that be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see Did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across when I was thinking it was going to leave the parade route. If you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade, and it went right to the, if you're looking at the parade, it was on the right-hand side, and it's continued on into the parade.
Hold on, just for the record, she was using her hands during her testimony. I just need,
Left
that's okay. I just need to make a record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle, and I think that's probably all I need to put on the record about that. Go ahead, next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, it was, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was, all I can state is it wasn't speeding.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall, I'm sorry.
Any windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have had clipped me or the two people that were in front of me.
Were the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Good afternoon, Mr. Rell. Thank you for being here. You testified on direct examination that you don't recall whether or not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading witness.
Yeah,
Overruled, you may answer.
I can't be too sure.
Overruled, she may answer.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I might have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Okay. Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
All right, thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street, is that right?
Correct.
Objection, already answered that, asked and answered.
Overruled, she may answer.
You said correct?
Correct.
And after your children walked by in the parade, you walked in this direction towards the intersection of White Rock and Main, is that correct?
Objection,
Correct.
leading and speculative.
So overruled as to both, you may answer. If there is another objection, just
I'll
wait
pause.
until I rule on it.
Sorry.
Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street, is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes.
So you were standing in the crosswalk.
Correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Okay. Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes.
unless they were part of the parade?
Yes.
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Urel?
Objection, irrelevant.
Overruled. You may answer.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection, leading.
Overruled.
Sorry again.
Your oldest daughter, Charlotte, she was 14 at the time?
Yes.
Thank you.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection, it's overruled.
I didn't even state why I was objecting, but okay. We still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection, leading.
Sorry.
Overruled.
Again, sorry.
Objection, hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection, leading.
Overruled. You may answer.
I was only able to see 2 of my children that night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care and the decisions that were made in that process in the days after the parade?
Objection, leading.
Overruled. You may answer.
Yes, their father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection,
Sorry,
leading.
Mika.
Overruled. You may answer.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the extreme dance group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection, leading.
Overruled. You may answer.
Yes.
And road rash
Extreme road rash.
and a lung contusion
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021, is that correct?
That is
Objection,
correct.
leading.
Overruled.
He was walking with the extreme dance group handing out candy, is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur, is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection, hearsay. I don't believe he's a doctor.
Overruled. The witness may answer based upon personal knowledge.
Was that a guess?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound, is that correct?
Yes.
I don't have any other questions.
Any redirect?
No redirect.
Thank you, ma'am. You may step down. You may call your next witness, please.
So we gonna take down these exhibitors, he gonna stay up on there?
Thank you. We'll take it down. Please call your next witness.
Just 1 second. So you want more person here, right?
It's my understanding, sir. Would that be correct, Attorney
Yes.
Upper?
Yes, she's in the courtroom, ready to go, Your Honor.
defense calls Catrice. I don't know how to say the last name.
Can you give me the spelling that you have?
Babiaz.
Like it's Babiaz? What's your last name?
Fabias.
Fabias. All right. Thank you. You are at the witness stand. Would you please raise your right hand? My clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record, and then spell each.
Catrice Babias, Katrice Babiazz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Babias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of November 21st, 2021, were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn? Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand, waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained us to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Let me back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did the driver look?
The driver looked like through me.
What do you mean through you? Describe what you mean by through you.
I feel that it is very hard to explain that look, but it was very frightening.
I think Judge Darrow just saw it about an hour ago. I think we all saw it.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt or sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the vehicle...
Hold on, I just need to make a record of, she was also using her hands, that's okay, to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes.
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Do you recall, well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle?
Yes.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't, to be fair, you said you didn't know. You said it was that week is what you said. The same week. You spoke with FBI agents, reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh. But you didn't report this at any time whatsoever.
That went way over his head.
Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to the incident?
No, I did not.
So is today your first time bringing up your alleged injury?
No, it is not.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
You contacted the Ms. Peterson after receiving the subpoena?
Correct. The instructions told me to.
Okay. You ever spoke with anyone directly at the district attorney's office?
No. Correction. Yes, when I walked in today, I met there and let them know I was here, and then they walked me into a room, and I waited until I was called by you.
So before today, you had no interactions with anyone related to the district attorney's office besides I think you said victim advocate?
So the victim advocates who I've been in connection with and letting me know when to come and all of that.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
And I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never
swing and a miss.
Witnessed a trial, sat at a trial, been in a trial?
I have not.
Have you ever testified in any way before today?
Judge Rollins.
Grounds?
Overruled, you may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and a district attorney would sit in a courtroom, correct?
I know where they're sitting, yes.
I want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for the...
When it was approaching,
When it was,
question was when it was approaching.
I'm confused.
Hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep. So I saw that an officer have to get out of the way, and he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received 2 separate subpoenas?
Correct.
What was the difference between the 2?
One was from the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor. If I may
just
have
to object to this line of questioning. I really don't know what the relevance is for the purpose of this trial.
There was no objection at first.
But there is now.
I'm going to sustain the objection under 906.11, because I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir. Go ahead. But I'm sustaining it as to the form of a question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained. You don't have to answer that. I sustained the objection on those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection. Relevance.
Grounds.
Sustained.
Grounds for the sustained. That
Not
was
relevant.
What? Mind-boggling.
You're mind-boggling.
Sir, in July when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection. Relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness.
The subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906.11, please ask the witness a
This is
relevant and
mind-boggling.
probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the sustained.
It's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
that's- I think
I'm
that's very
sustaining the
relevant.
objection under 906.11, and I'm asking you to move on.
Y'all, this ridiculous, man. Seems to me like a like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued before.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 90611, you are directed to ask a question, or I will ask the state if they have any questions.
I heard you.
Thank you. Next question, please.
You know who the plaintiff is in this matter?
Yes,
Who's the plaintiff?
the state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Relevance.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir. Mr. Brooks, ask your next question.
I'm going to get to it.
Thank you.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
90611, sub 1, sub A, sub B, and sub C.
is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
He's like, should we cross? Kind of find out if it's worth it their time or not.
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overruled, the witness may answer.
Of course it's going to be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
Ma'am, when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question I asked.
The state can ask their questions.
So how
Go
come when
ahead.
I did that,
Overruled,
it was
the witness may
it was
answer.
sustained?
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I'd ask that the screen be cleared. And ma'am, does this show...
Can you wait till it's in the jury box? I'm sorry. The jury would let me know when it's there. Thank you, it's there now. Go ahead.
Ma'am, do you see a purple line that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were barricades that were partially blocked. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Okay.
Overruled.
Hearsay.
The witness may answer. It's not hearsay.
So when the red SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is correct.
Yes, hearsay. She's speaking as a
Hold on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's always overruled.
Go ahead, you may answer, ma'am.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes.
Okay, yes.
Okay, thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
Overruled. The witness may answer. Go ahead.
Give me answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
No, I'm talking about you.
The objection is noted. It's overruled. The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was, no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
overruled. The witness's answer may stand.
And you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection. Speculative.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one was been where we were on Main and White Rock, and then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley, and there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Main.
Okay. And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled, the witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. Let me read the rest.
Yep. You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one at, I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that the interview that was conducted with the FBI, that was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why it wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. Would that be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny.
The one that asked
Seems
the
almost
question.
as if you're recalling what you want to recall and purposely not recalling.
Objection.
Don't.
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue? What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding
That's
her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't-
ask
you really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I made my ruling under 90611.
specifically
Please
said
ask a
intimidate.
question or
I'm trying
I
to
will
merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even
end.
a judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62Q trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
And you even gonna call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None.
What a clown.
None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the
just
state that
know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to
We
have her
said- we
here
said
at
all
9
that-
a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I need to make a record too.
You don't.
When
need
am
to-
I gonna get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so
down
we'll do it
for
now. You
the
can
better
hold
part
me in
of 2
contempt
hours.
all you want. You can hold me in contempt all you want.
I'm not
All
holding
gotta
you in
do is tell me
contempt.
if it's criminal or civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna
make.
give you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you
that
and I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what is
He
this?
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to
Mr.
the
It
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity.
Thought your
How
name
can
wasn't
you even
Mr.
call
Brooks.
yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
Ah, that means we have to wait a little more still to see the end to end. It's almost done. Ah, man. Well, the jury got excused. He's going to be removed again, so she can give the final discussion with the prosecutors. It sounded like 9 a.m. though on Monday. 9 a.m. Monday for when we'll resume after this. Might be having to schedule the war coverage for 7:30. Might be having to schedule that one for 7:30 tonight. Like the video if you haven't. Make sure you're following the page. Subscribe to the YouTube channel. Still going for a little bit here. Or we're not. Okay, well this feed's cutting. Let's go to Okay, well, they're ending that. Are they really ending it? They better not. I went to another feed of inside the courtroom. Well, the Fox feeds were ending. It's too bad for that audience. No, we're still going. We're still going too. We still got the live feed of the clock. I don't know how long this is going to take. It's got to be like at least 5 minutes to get him to the other courtroom. I think Brooks takes a cake for one of the top worst people of the year. He's definitely in the top 5. Tell you what, after these court proceedings, I'm drained. I gotta go get an energy drink in between this or something. These court proceedings, these ones, I've done other ones. We've covered plenty of other court proceedings, some pretty big ones. This one though is probably the most tiresome, but also you just can't stop because we gotta see it through. He's the court's coming back, yes, still today, but he is not. He's done. All right, he's in the other courtroom right now. The jury is not coming back. All right, here we go. I'm hearing noise.
Not yet, okay. Okay, that's fine. Just need to know. Can they confirm that the audio and visual is working? We don't need a clerk per se. We just need to know that the audio and visual is working.
It is. Am I muted?
Also posted on YouTube and Facebook is today's map update from Ukraine. So after we're done here in the next 5-10 minutes, go check that out. Shout out to editor Larry for editing it together and getting it posted every day at 2 o'clock, even while we're live here. So sometimes that gets missed just because of these trial streams, but after this is over, just go check out the newest map update if you want to get an idea of what the coverage is. And then during the live feed, I also react to videos too. So lots coming out of Ukraine.
Record to reflect that Mr. Brooks is in the adjacent courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues. But before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. and it was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which they did.
There's
and
echo.
At the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness, who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word, it's a synonym for badgering. Clearly he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings.
Y'all think he'll testify? Yes or no in the chat? Put yes or no.
Then ask him whether he's made a decision, and then ask what that decision is, and then based upon his decision, I of course will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146 Wisconsin 2nd 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 90611. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial, and of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So, just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks, and I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of right now, Your Honor, just so you know for timing.
Thank you, I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. And it's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes. Sure. With the hope of, and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with, so I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared, perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions, and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now.
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the two photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Miss Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Miss Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Miss Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She never went on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Good.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of at this point on the topics that have been raised.
Am I unmuted?
Sir, anything you wish to address before we break for the day?
Yeah, I can. I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them. That has yet to be done. I've put you on notice and I've stated it on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up. 4 against 1.
You sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we gonna strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt. Why was the bond not addressed? Why was the statement of particulars not addressed? No filings that I seem to file need to be addressed. After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel, and you accepted that. But you still turn around and continue to violate my Sixth Amendment right. You violate my First Amendment right by telling me what I can and can't say, which I have the right to say whatever I want to say and to be heard. That's the First Amendment. You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but that it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceedings. But yet still you choose to find a way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction, for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair. Doesn't constitute being impartial. When the jury was selected, I struck the whole jury. That never got addressed in any way, shape, or form. When you knew, when you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant.
Rambling.
He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
All right, everybody. Oh my goodness. Oh my goodness, over 9 hours of coverage today. If you could leave a like on the video, make sure you follow the page on Facebook, subscribe to the YouTube channel with your notifications turned on. This concludes day 12 of the state of Wisconsin versus Darrell Brooks. I'm Andrew Mercado, independent journalist, U.S. Army veteran. Thank you for supporting independent media. We'll be back tonight in a couple hours, a little under actually, about 7:30, 7:45-ish. All right, I might need a little extra today because it was a long one. So I'll be back live again, y'all. Have a good one. Take care. Have a good weekend. See y'all on Monday for trial coverage. See you then.
Thank you.